잠시 후 10시부터 2024년 국제특허법원 컨퍼런스 1차 일정이 시작될 예정입니다. 참석자 여러분께서는 회의장 안으로 입장해 주시기 바랍니다. 곧 오늘의 프로그램이 시작될 예정이오니 장외에 계신 분들께서는 회의장 안으로 입장에 착석해 주시기 바라겠습니다. 아울러 원활한 행사 진행을 위해서 가지고 계신 휴대폰은 잠시 꺼주시거나 진동으로 전환해 주시면 감사하겠습니다. 어제와 같이 본 개회식은 동시 통역이 제공되고 있습니다. 한국어는 1번, 영어는 2번의 채널을 맞춰주십시오. Simultaneous interpretation is provided for the conference. Channel 1 is for Korean and Channel 2 is for English. 이제 10시가 됐습니다. 4세션 패널리스트들께서는 무대로 올라와 주시기 바랍니다. Panelists for session 4, please come up to the stage, please.
Judge Feddersen, where are you? Judge Feddersen? Oh, yes, please. Please join our panel, right?
여러분 안녕하십니까? 한지윤 판사입니다.
Hello, this is Judge
어제
Han.
편안한 휴식
Hope you
취하셨길
had
바랍니다.
a great evening
오늘
yesterday.
오전에도 아주 유익한 세션이
And
준비되어
we
있습니다.
have
10시
some
정상에
sessions ready for you
시작되겠습니다.
today as well. So we will begin the fourth
지금부터
session
2024년
at 10 a.m.
국제컨퍼런스
So we will kick
특허법원
off
컨퍼런스
the
4세션을
2024
시작하겠습니다.
International IP
이번
Court
세션에서는
Conference.
소송 절차의
Session 4.
효율적
In
운영을
this
위한
session,
각국의
we'll
실무에
be covering
대해서
the topic of
살펴봅니다.
best practices for efficient litigation
본
process.
세션을 이끌어
And this will be led
주시겠습니다. 큰
by
박수
Young-gi Kim,
부탁드립니다.
IP High Court Judge of Korea.
Okay, good morning, everyone. How's everything going today? Hopefully, all of you are enjoying this conference as much as possible, especially the gorgeous view from this venue, right? Yes, I am Judge Young Kim from IP High Court of Korea, which is the very first IP specialized court in Asia. And welcome to this very interactive session with very well-renowned judges about IP litigation system. An efficient litigation process is one of the key challenges for courts around the world these days. And to achieve the goal, each jurisdiction has adopted various systems and legal instruments. Can you have the slide? Oh, no, not yet. Okay, this one. The title of this session is Best Practices for Efficient Litigation Process, which will specifically focus on patent infringement litigation and revocation appeal procedure. And we will take a journey from filing a complaint to a judgment and appeal. For fruitful discussion, we already exchanged long questionnaire And as a moderator, I picked up a very interesting and crucial topics for discussion. I'm sure that this session will provide us the best opportunity to understand and learn from each other and to find which one is the better. Okay. Now, let me introduce our renowned special speakers for our session. For this session, like the last year, an amazing 4 judges have joined us. I will introduce them under the doctrine of ladies first. Okay, we have Honorable Judge Kiyo Matsumoto from the Eastern District of New York, United States. Good morning, Judge. Yeah, how do you feel this morning?
Well, thank you. Good morning.
May I have a quick question? I like the photo, so when was it taken?
You can tell I look much younger. That was an original court photo that was taken of me when I first became a judge. So it's quite old, and I'm quite old too.
Oh, really? I thought it was just yesterday. Yeah, honestly, Your Honor. Okay, next to her, we have Honorable Judge Jörn Feddersen from Federal Court of Justice, Germany. Hey, Judge, are you enjoying this conference?
I'm enjoying myself very much. Thank you very much.
How was it, last night's performance, Korean music performance? Did you like it?
It was so beautiful. I was really blown away. It was so lovely.
I'm so happy to hear that. Okay, we also have from Tokyo District Court, Honorable Presiding Judge Masaki Sugiura. Good morning, Judge. I heard that this is your 3rd visit, right, to Korea? Which one is the best?
This time is best. Of course.
Perfect answer. Thank you. And last but not least, we have Honorable Judge Jae-pil Yoon from IP High Court of Korea. Thank you so much for joining this session, Judge Yoon. Okay, before jumping into our session, just housekeeping comment, I have this one. Actually, this session is prepared for very comfortable discussion among the judges, so it's a little bit different from other sessions. Please understand that. Okay, let's start with a very general question. The question goes like this. Judges, are you ready? Okay. Please introduce one of the most significant measures of your country adopted to handle patent infringement litigation or revocation appeals efficiently. Who will go first? Any volunteer? Oh, Judge Matsumoto.
Well, in the United States, the district courts are courts of general jurisdiction. So unlike many courts, including those of my colleague Judge Cheney, who you heard from yesterday, we are not specialists in the fields of engineering, science, and technology. Rather, for example, I was a journalism major in college. So we handle all matter of civil and criminal cases. And one of the significant tools that we use for case management are the federal rules of civil procedure, our local patent rules, and also the claim construction procedures set forth in the Markman case. This is a hearing during which parties present evidence and ask the court to construe the meaning of the claims. That construction helps define the course of the litigation and the parties' conduct of the litigation. Thank you.
Okay, thank you, Judge. And let's visit Germany. How about in Germany, Judge?
Thank you very much. Now, as you, of course, know, Germany patent law follows the system of bifurcation, which means that revocation and nullity proceedings and infringement proceedings are to be pursued in different court venues. Infringement suits start at the district court, Landgericht, and in order to facilitate specialization, the Patent Act allows to award exclusive jurisdiction to specific district courts over patent suits in one or several states. So the most important patent infringement venues, as you know, are the district court in Düsseldorf, Mannheim, Munich, and Hamburg. This enumeration sounds familiar after yesterday when we heard about the UPC. So maybe it's no accident that the 4 German local chambers are located in these cities. The district courts decide as specialized panels of 3 legally qualified judges, and those decisions are subject to appeal to the higher district court, which again decides by a panel, specialized panel of 3 legally qualified judges. Legal review of decisions on appeal lies with the Federal Court of Justice, with my court in Karlsruhe, in fact the 10th Civil Senate, and the panel sits as a specialized panel of 5 legally qualified judges. If the higher district court grants leave to seek review, I must add, or the Federal Court of Justice sets aside the higher court's denial of leave to seek review. Now, as I said in the beginning, exclusive jurisdiction over revocation appeals and nullity proceedings lies with the Federal Patent Court in Munich, Bundespatentgericht, which means bifurcation, that invalidity of the patent cannot be invoked as a defense or counterclaim in infringement proceedings. However, infringement proceedings can be stayed while revocation or nullity proceedings are pending. The Federal Patent Court decides upon revocation appeals as a panel of 2 or 3 technically qualified judges and 1 legally qualified judge. A panel of 3 technically qualified judges and 2 legally qualified judges handles nullity proceedings. Also, revocation decisions of the Federal Patent Court are subject to appeal, again to the 10th Civil Senate of my court, the Federal Court of Justice, under the prerequisite that the Federal Patent Court grants leave to appeal, or again the Federal Court of Justice sets aside the denial of leave to appeal by the Federal Patent Court. And nullity decisions of the Federal Patent Court are subject to legal review by my court, always. Thank you.
Okay, Judge, when you say court in Hamburg, is in Hamburg, not in Hamburg, right? Hamburg. Okay, thank you. And I heard that the remote conference trial is popular in Germany, right? Remote conference trial, the judges stay in different places and have...
In fact, yes, our Code of Civil Procedure provides for the possibility of a trial by video conference. In fact, we had this provision included in our Code of Civil Procedure for more than 20 years, but I think you could call it at those times the sleeping beauty of Civil Procedure Code, because it was very rarely used. And then what happened? COVID came and kissed the sleeping beauty awake. So that's a weird metaphor right there. And then we had, during COVID, we had thousands of video conferences. I'm very interested to hear about my colleagues, but I'm quite confident that we are all in the same place as to this feature. It was the understanding, it was basically no question that the court had to be present at the location of the court, and then the parties and witnesses and so on could be included by video conference. We learned during COVID, I think maybe this is also a shared experience, that the more flexibility you have as to procedural rules, the better we can cope with crisis situations. So after COVID, finally was gone, discussions emerged how to facilitate video conferencing even further. And so the discussion concentrated on the question whether even the court should be allowed to be at a different place than the location of the court.
Okay, Judge, thank you. Very quickly then, do judges prefer the video conferencing trial or to just traditional one? Just quickly.
I think we heard that yesterday from Judge Kelden, and I very much concur with that view. I think this is also a shared experience. Okay, I'm sorry, I'm talking too much. Now, I would always prefer a personal oral hearing over a video conference. You want to see your opponent freeze in shock by upon a word of the judge, right? You want to see the facial expression of the judge while you make your argument. You want to factor in all this information in your trial strategy, and we all know that communication is not only about distant visuals and sounds, but there's non-verbal communication that is very important, and I also want to see the face of my judge colleagues, my fellow judges, when they say something. So really, I think I would always prefer a personal hearing over a video conference.
Okay, thank you, Judge. I think that Judge Sugiura is expecting his turn, but let's visit Korea first. How about Judge Yoon?
It's an honor to discuss these important topics with distinguished expertise. While preparing for this session, I realized the countries around the world are putting in a lot of effort to improve the efficiency of litigation process. Now I'd like to introduce an important change happening in Korea. One key measure introduced is, of course, jurisdiction centralization. And at the center of this system is the Intellectual Property High Court of Korea. The IP High Court of Korea was established in 1982 and exclusively appeals against decisions made by the Intellectual Property Trial Appeal Board, IP10. At that time, infringement lawsuits concerning registered IP rights such as patents, utility models, trademarks, and design were treated like general civil cases in terms of jurisdiction. However, with enforcement of the amendments to the Civil Procedure Act and the Court Organization Act in 2016, jurisdiction over infringement lawsuits became more centralized. Since then, first instance jurisdiction has been assigned to 6 district courts located in regions with high courts, and appellate jurisdiction has been centralized in the IP High Court. This concentration has been praised by both academics and practitioners for enhancing the expertise and efficiency in handling cases. Currently, discussions are underway within the Presidential Council on Intellectual Property to extend this centralized jurisdiction to other types of cases that require specialized understanding and analysis of intellectual property. These mainly include trade secret and preliminary injunction and criminal cases related to patent infringements. At the IP High Court, High Court Judge Young-gi Kim and Gis Kim are also participating in this council. I'd like to this opportunity to thank both of them. Thank you.
Thank you, Judge Yoon. You're sharing the concentration of jurisdiction in Korea. Thank you. And Judge Sugiura, it's your turn.
Sorry. I think the most significant measure is the exclusive jurisdiction on patent infringement litigation and revocation appeals. The Code of Civil Procedure provides the exclusive jurisdiction of Tokyo and Osaka District Court for the patent infringement litigations, and the Tokyo District Court has 4 specialized divisions for IP cases, and Osaka has the 2 divisions for them. And IP High Court of Japan has the exclusive jurisdiction for appeals against the judgment by the aforementioned district courts. And the Patent Act provides the exclusive jurisdiction of IP High Court as a special branch of Tokyo High Court for the litigations against the decision on the trial or appeal by Japan Patent Office. These provisions on the exclusive jurisdiction for patent litigation aim to increase the effectiveness and efficiency of court proceedings and enhance the specialized judicial system for IP-related cases by the extended experience of judges and other relevant court officials. I think especially from the viewpoint of capacity building, it is important that this gives young judges will form a close relationship among relevant players related to IP judiciary. Thank you.
Thank you, Judge. I heard that you also have technical advisors in your course. So very quick follow-up question. Are they a full-time worker for your court, or they are just appointed for specific case temporarily?
Thank you for your question. Technical advisors are part-time national officers appointed by the Supreme Court, consisting of leading experts such as university professors and researchers of public institutions. They provide explanation on the highly specialized and technical matters in dispute based on their expertise. On the other hand, judicial research officials are full-time court staff members, consisting of former JPO trial examiners and patent attorneys. Thank you.
Okay, here I think we find very similar practice among Korea and Japan because we are neighboring countries. Also, IP High Court and Seoul Central District Court also have full-time technical advisors in court. Okay, Justin, right? Yes, okay. It was a very general question. Now it's time to get into the main point from the filing complaint. Let's circle back to United States. This question goes to Judge Matsumoto. Does your court provide guidelines to parties on the necessary information for a complaint? What measures does your court take for making them to? And what is the sanctions for failure of compliance?
There are no specific guidelines as to what a complaint must include, but the United States Supreme Court in 2 related cases, you've probably heard of Bell Atlantic versus Twombly and Ashcroft versus Iqbal. These were decided in 2007 and 2009, required that a complaint must allege sufficient facts to state a plausible claim for relief. Federal district courts have applied different pleading standards alleging direct infringement and indirect infringement, and they may require additional facts. At a minimum, the facts alleged have to state a plausible claim. However, if a complaint fails to state a claim, or if a defendant believes it does, then it may move under the Federal Rules of Civil Procedure 12b-6, which is dismissal for failure to state a claim. There, the court will construe the complaint in the light most favorable to the plaintiff and assume that all the facts alleged are true. Then the court has to evaluate whether those facts taken as true will state a viable claim. If it does not, the court may dismiss the complaint, generally with leave to replead, meaning that the plaintiff gets another bite at the apple. In order to improve efficiency, what I and my colleagues often do is if a defendant wishes to make a motion to dismiss for failure to state a claim, we will have a conference and I will ask the plaintiff whether there are additional facts that they can allege that will satisfy the defendant's view that the statement of facts is not sufficient to state a claim. And oftentimes they will take that opportunity, and I will save the trouble and expense for the parties of making a motion.
Thank you, Your Honor. Then those kind of things are specified in your local patent rules, right?
Not just the local patent rules, but also the federal rules of civil procedure, which apply also to patent cases.
Okay, thank you. Then how about in Korea, Judge Yoon?
Thank you. Except for the general provisions set by the Civil Procedure Act, there are no specific guidelines related to patent infringement. However, there are guidelines in place after submission of the appeal brief. Upon receiving the guidelines are available on the official website of the IP High Court. These guidelines are also available in an English version. Upon receiving an appeal brief, the court issues an order to prepare for elucidation, requesting the parties to refer to the guidelines on our website, including the link when submitting claims or evidence. It also notifies that non-compliance may result in disadvantages such as the court refusing to accept claims or evidence submissions under Article 149 of the Civil Procedure Act. The guidelines set out the basics for argument and hearing procedures, aiming to enable swift, efficient, and specialized trials. Given the court's specialization, most representatives are well versed in its practice, leading to general adherence to the guideline. However, as the guidelines just guidelines, parties cannot be penalized solely for non-compliance.
Okay, when you say guideline, it means that the practice directions for civil appellate trial and revocation trial, the formal name, right, of this IP High Court. Okay, thank you, Judge. Okay, let's forward. Okay, this phase is early stage case management. This question goes to Judge Sugiura first. Question is like this. Does your court establish a plan for case management at an early stage? If so, what does this process entail, and what measures can the court take if a party does not follow the established plan?
Thank you. In many cases, the court establishes a plan for case management in the initial phase. The plan will be established based on the discussion between parties and the court. In the plan, the court will set the frequency and deadline for submission of preparatory documents and evidence from each of the parties, and may set the date for explanatory session about the allegation if necessary. Therefore, on the process to establish the plan, the court will look forward to lead the discussion actively, but not play the decisive role. If the party has presented after the deadline to submit allegations or evidence intentionally or through gross negligence, and the court finds the conclusion of litigation will be delayed because of it, the court may rule to dismiss such allegations or evidence without prejudice upon petition or sua sponte.
Okay, thank you, Judge. Before I move to another judge, I want to just add one more comment about the current practice, about the guidelines. As Judge Yoon mentioned, there is no harsh sanctions against those guidelines, but it might affect the result of the case, right? Because the judges don't like they're not complying with the guideline, right? Okay, thank you. And then how about just visiting Germany, Judge Feddersen?
Thank you. Now, first of all, there are no special requirements for filing patent infringement actions, and also the courts usually do not provide guidelines in advance. However, and we heard about that yesterday, and I very much sympathize with the statement that that Judge Cheney made here, who said that the enforcement of deadlines is key to expedient trials. And this is very much the spirit, I think, that also is reflected in the German procedural law, because each party has, the option to, first of all, obviously the plaintiff has to state his claim, then the defendant can reply, then the plaintiff can again answer to that, and then the defendant has another chance to reply, and then the case will be resolved in one hearing. And in the meantime, if the court finds that information is lacking, it will advise the respective party and tell the party, this is not sufficient, either the claim or the defense. Of course, having in mind the fundamental rights to a fair trial and efficient judicial remedy, fundamental rights, not only in Germany, I suppose. So this duty to notify the parties is very important. And also, after all this business has been concluded, if the deadline is over, you run the risk that your facts that you present too late after missing the deadline will not be considered, and you don't want that. So you rather comply with the deadlines.
Okay, thank you, Judge. Judge Matsumoto, United States is very famous for its case management conference. Could you share your practice about that?
After a case is filed and the defendants are served with a summons and complaint, a court will issue an order scheduling an initial conference. And at that conference, in a patent case, the court will set deadlines and dates for certain proceedings. For example, claim construction filings and hearings, proposed expert discovery, a proposed format and deadlines for service of infringement, invalidity, and or unenforceability contentions, dates for disclosure of claims and infringement contentions identifying prior art that allegedly renders obvious each of the asserted claims, and any other grounds for invalidity or unenforceability. The parties must update and supplement their responses, which could cause some consternation when there are updates, but it is an obligation. What you don't want is unfair surprise. So if a defendant is going to rely on advice of counsel, they must disclose the opinions of the counsel on which the alleged infringer relied, and provide ultimately, after conferring with the parties must provide a joint disputed claim terms chart with proposed constructions for the court to consider. The court will then consider any motions or trials or hearings.
Okay, thank you, Judge. Let's move to next step, next phase, the pre-trial evidence collection. Let's start with Judge Sugiura. Yes, the question goes like this. There are two evidence collection systems primarily used worldwide. One is the discovery system used in common law, like United States, and the other is the judicially led evidence collection system. Question, would you share your court's evidence collection measures in detail, which has been specially adopted for effective evidence collection? And another thing is, what measures can your court take if a party fails to comply with?
Thank you. In Japan, parties should submit allegations and evidence according to the burden of proof, and the court should make its decision based on them submitted by parties. Therefore, the parties bear responsibility to collect evidence primarily. In order to collect evidence, parties can file the petition for preservation of evidence and dispositions on the collection of evidence against the court before the filing of the complaint. After filing the patent infringement litigation, in order to collect evidence, parties can file petition for an order to submit documents provided the Civil Procedure Code and Patent Code. And motion for issuing an investigation order to an investigator provided the Patent Act. In case that the adverse party of preservation of evidence, the order to submit document and the investigation order fails to comply the order without legitimate reason, there are some sanctions. If the adverse party is the litigation party, the court may find the allegations of the party that offers these measures to be true. If third party, the court issues a ruling sentencing him or her to a civil fine. Thank you.
Okay, then Judge, I'm interested in your preservation of evidence system. I think we, Korea, have very similar system. So is it often used in Japan, and the motion for preservation of evidence is granted well?
Honestly speaking, there are many, a few cases. The number of petitions for preservation of evidence related to IP cases in Tokyo District Court counts about 5 per year. On the other hand, I've never experienced and heard the petition for disposition on the collection of evidence related to IP cases. It is pointed out that there are some problems such as efficiency, effectiveness, and difficulty of procedural requirement when considering pros and cons. Thank you.
Okay, thank you, Judge. And then how about in Germany, Judge Feddersen?
Now, the German law of civil procedure does not provide for common law style discovery. But obviously, in many cases, if the product is not readily available on the market that you assume to be infringing, you have to have some means to get a hold of the potentially infringing embodiment. So there are a couple of claims in the German substantial law to get to that for that purpose. I also should say that evidence collection is led by the court upon application of a party. So no discovery. It's all up to the court to collect evidence upon application of a party. So we have a couple of claims that enable the patentee to request the other party to present the contested embodiment or to inspect the contested embodiment, but these substantial claims have a prerequisite of probable infringement. So what do you do if you just don't know whether the embodiment is infringing or not? So there's another procedural measure which is called independent evidentiary proceedings. And this is a very low hurdle to take because you can apply for this independent evidentiary proceeding if there is the concern that evidence might be lost or that it will become difficult to use it. So of course you need some, facts that justify this claim. Maybe previous behavior by the other party, suspicious behavior, concealing things. But more importantly, there is even, I think, a lower bar, you would say, because these evidentiary proceedings can also be initiated if regarding to the state of an object, examination of the state of an object, meaning the embodiment, if the applying party has a legitimate interest in establishing such evidence. And the provision itself tells us what a legitimate interest can be, namely if the establishment of these facts the state of an object may serve to avoid a legal dispute. And that is a very broad prerequisite because, I mean, what are we doing? No, we actually are deciding trials, but what are the lawyers doing? They are trying to avoid trials. And in order, if you want to find out whether an embodiment is infringing or not, you are basically under this broad provision that you are trying to avoid, or possibly trying to avoid trial. So this is a quite low bar, as I said, for getting access to the contested embodiment. And I should add, in very generally, that if the other party doesn't comply with it, then the full force, the full police force will come and support the bailiff, upon getting access to the contested embodiment.
Thank you, Judge Patterson. I think even though you do not call the preliminary inspection proceeding as discovery, but it sounds like one of the discovery in the United States. So is the preliminary inspection proceeding often used in your court?
Now, this is something I really love about comparative law, comparative procedural law. We might, have the feeling that everything is different everywhere and that we call things different names, but we all are, working toward the same or similar goals. So we use methods that are kind of similar. And so I have to agree. As I said, the bar is very low. And also, I mean, I apologize for not being an expert, but I think even in discovery, a court might be involved, granting discovery to certain documents and so on. So yes, it's maybe not that different, and it's a very effective and also very often used method.
Very often used. Oh, good. Okay, then how about in Korea, Judge Yoon?
When I listen to Judge Sugiura, I feel we share similar changes. Yeah, I think. Yeah. In South Korea, the Civil Procedure Act doesn't include discovery process like in the US. Yeah. I can say we have a judicial-led evidence collection system. In patent infringement cases, parties can request a material submission order to compel the opposing party to submit evidence. This provision is more powerful than the document submission order under the Civil Procedure Act. Notably, under the Patent Act, this order extends beyond only documents, even if the requested material contains trade secrets. The party cannot refuse submission if the information is essential for proving infringement or calculating damages. If a party fails to comply with the order without good reason, the court may deem the opposing party's assertions regarding the content of the material as true. Furthermore, if it's highly impractical for a party to make detailed claims about the contents of certain materials, and proving the facts with other evidence isn't realistic, the court may deem not only the contents of the materials, but also the facts the party aims based on them as true. Additionally, a party may apply to the court for a preservation of evidence under the Civil Procedure Act. For evidence preservation, a preliminary hearing isn't required. Only notification of the date of evidence collection is needed. Moreover, if there are urgent circumstances, even this notification can be skipped. The only condition for this procedure is that without preserving the evidence in advance, it would be difficult to use it later. It doesn't need substantial suspicion of infringement. Yeah. However, the need for preserving evidence seems to be judged quite strictly, and some people believe that this strict standard creates an obstacle to more active evidence preservation.
Okay, thank you, Judge Yoon. That's why we have much interest in adopting some U.S. systems. So, Judge Matsumoto, United States is famous for its discovery, right? Yeah, so even though it has some pros and cons. So would you just elaborate on the sanctions about the discovery? And one more question is that the sanctions could be imposed often against the parties? Would you?
Yes, in the United States, the federal rules of civil procedure govern discovery. The scope of discovery is very broad. As long as it is non-privileged and is relevant to any party's claim or defense, it may be discovered. So discovery comes in different forms. You can ask written questions and ask for a verified answer, meaning it has to be verified by a person with knowledge. You can ask for documents. You can ask for inspection of an object. And if a party does not comply, the first step is to obtain an order compelling discovery from the judge. The judge will then set a date by which the party must comply with the discovery request. If the party still refuses or fails to comply, Rule 37 of the Federal Rules of Procedure provide a broad range of sanctions. One cannot apply for sanctions until there has been an effort to consult in good faith with the withholding party and try to resolve it. But when you do invoke the judicial power to resolve a discovery dispute, the court may order the following sanctions. It may order that the matters embraced in the order or other designated fact is taken as established, similar to Japan and Korea. It may also prohibit the disobedient party from supporting or opposing designated claims or defenses, or from introducing designated matters in evidence. It may also, the ultimate sanction is dismissing the action or proceeding in whole or in part, or entering a default judgment against the disobedient party. The court also has inherent power to impose a contempt order, which is an order that has both civil aspects, meaning I can impose a fine of $100 per day until you comply with my order. And there's also criminal contempt, which is really the ultimate sanction where you can imprison somebody for not complying, but that rarely happens. So yes, sanctions are available. The court can also award the cost of attorney's fees against the withholding party if a motion to compel is necessary.
Thank you, Judge. And all the sanctions are stipulated in your FRCP, and also you have inherent power, right?
Yes, we do. Thanks to Article 3 of the Constitution, the courts have inherent power to manage their dockets in a way that addresses the interests of the parties, the public, and moves the litigation along in an expeditious and fair manner.
Yes, I'd love to take your inherent power. I like it. Okay, we have a long way to go, so let's move forward. This pre-trial and trial phase. Let's United States again. Judge Matsumoto, I'm sorry to ask you again. Question is like this. Are there specific directions or procedures that courts or judges adopt to ensure efficient hearings during the pre-trial and trial phase?
Well, in addition to what I already described with the pretrial conference, there are also methods within the Federal Rules of Civil Procedure for a quick disposition. Those include motions for summary judgment, and they usually occur after the parties have had an opportunity to exchange discovery of the facts, and once a party realizes or decides that the facts, certain material facts are undisputed, a party may move for summary judgment, meaning they can ask the court to award judgment in that party's favor based on the undisputed factual record, and they must present not only the undisputed facts, but also a legal memorandum showing that as a matter of law, that party is entitled to judgment. So Celotex Corporation versus Catret is a Supreme Court case decided in 1986, which established and urged parties to consider summary judgment. So that is a very effective tool to get to judgment without a trial.
Okay, thank you, Judge. You shared summary judgment practice and JMO practice, right? It is very strong framework for your court.
JMAL is judgment as a matter of law, and that occurs at the trial phase. Once a party, like a plaintiff, has been heard fully in presenting its evidence, the opposing party may move for judgment as a matter of law, either on a claim or a counterclaim. So the plaintiff can also make this motion. What the party must show under Rule 50 of the Federal Rules of Civil Procedure is that the party has been fully heard and the opposing party makes the argument based on the trial record that the facts are insufficient to support a judgment in favor of the plaintiff, or they are insufficient to support a defense that a defendant has raised. And the court will then basically withhold the case from a determination either of itself or by the jury and may enter judgment as long as the party has been fully heard.
Okay, so JMO is raised before the trial and after trial once again, right?
It's raised during trial after a party has finished presenting evidence, and then if it's denied or reserved, the losing party can then renew the motion within, I believe it's 28 or 30 days after judgment.
Okay, thank you. Then Judge Yoon, could you share some Korean practice about this matter?
Yes, thank you. When the IPI court schedules the hearing, it sends an order to the parties requesting them to submit a summary of the key issues at least 7 days before the hearing date. This order includes guidelines for preparing the summary as well as information about the hearing procedures and requests for cooperation. For detailed information, please refer to the sample order form attached to the conference materials. Thank you.
Okay, thank you for your brief explanation. Yes, next phase is post-trial phase, but in this phase, I could find that there is common practice for efficient dispute resolution, that the courts, all the courts, are encouraging the parties to resolve their disputes through mediation, conciliation, or other ADR procedure. Like Judge Rader mentioned, settlement is the best, right? The judges. Okay. Next phase is the judgment, right? The most important thing for the judges. Let's visit Japan first. Judge Sugiura, question is like this. Does your country, Japan, have systems or practices that help judge reduce the workload of drafting judgment?
Thank you. We have no special system to reduce the workload of drafting judgments. We continuously make effort to reduce it, and submission of electronic files of documents by parties is one of the useful methods. At present, we are discussing and attempting the improvement of the format of judgment. For example, there are many cases that the court makes tables by Microsoft Excel. Oh, okay. Sorry. There are many cases that the court makes tables by Microsoft Excel describing parties' allegations and evidence in cooperation with parties and attaches them to judgments.
Oh, attaching some part of the argument or contentions. I think it sounds great. So does the judges like it, right? And how about the attorneys?
It's case by case. It's a very tough work to complete the table, but when we complete we made the complete table, it's very useful to share the common awareness between the parties and the court. For example, sometimes the defendant alleges defense of the invalidity, and in such case, there are some, or maybe 6 or 5, five or 6 or 10 variety of such defense. In such case, it's difficult to share the common awareness of the issues. But if we make such table, we can the awareness share easily.
Okay, thank you. Yes, lessening the workload of judges is common concern about the judges, right? Then attaching the part of the argument, how about the high court judges? Do they also like it, or the justice also like it? One more question.
In the judgment by appellate court, sometimes I watch they use the table according to the first instance judgment.
Okay. Then, Judge Matsumoto, would you share USA practice about this matter?
In the United States, we're lucky to have law clerks who are generally young lawyers who have passed the bar and have maybe 1 or 2 years of experience in actual practice, who come and spend 1 year with us in our chambers. So when we have a large case or motion, we have a conference, we talk about the legal issues involved, we receive the papers from the parties, and then we talk about how to draft a decision. So I believe, I don't know, were you going to show them that judgment or not? No? You don't have to. Okay.
Do you want me to share this one?
What I wanted to explain is, under Federal Rule of Civil Procedure 58, a judgment must be set out on a separate document. So what you see here is not any legal reasoning, it's just a simple judgment after trial. This involved a products liability claim against BMW for what's called a soft closed door, where the plaintiff lost a tip of his finger in a door that closed without notice. So in this case, the jury awarded over $1 million in damages. But what isn't here is the post-trial decision, we call it a memorandum and decision, which judges write. I believe my M&O in this case was about 80 or 90 pages, and in that decision what I did was, in response to BMW's motion to set aside the verdict, I set forth all the trial evidence that supported the plaintiff's judgment of over $1 million, showing why the jury's award was not out of line, that there was sufficient evidence to support it, and that the amount of the judgment did not shock the conscience in any way.
Yeah, thank you, Judge, for sharing this judgment. But after this very simple judgment, there might be some settlement, right? In many cases.
Yes, I had another case involving BMW, and it went through a 2-week trial. This was an alleged faulty tire pressure warning where the car ignited on the freeway. The young woman driving the vehicle had about $400,000 of jewelry in the car that she was driving to a trade show. So it was very hotly contested, no pun intended, but the jury awarded judgment against BMW. They filed an appeal, but during that process, after the judgment was entered, they negotiated a settlement, and the case was finished, and the appeal was withdrawn.
Okay, thank you, Judge. Actually, these days, Korean Judicial is also considering to adopt very good practice for simplifying our judgment. So I think it is a good example for us. Thank you. And let's move forward. And filing appeal. Always judgment is not the final, right? The attorneys like appeal. This question, let's begin with Germany. Judge Feddersen. Yes, question goes like this. Do your country's appellate court review the lower court's decision in an ex post manner, solely based on the case records compiled in the lower court, or continue the lower court's case and hear and review the case again?
Thank you. I have to apologize in advance because this is a little bit complicated and technical stuff, so bear with me, please. Now, the appellate courts, the higher regional courts, as I mentioned earlier, base their decisions on the facts established by the court of first instance. This is like the ideal situation, unless specific indications give rise to doubt as to the court having correctly or completely established the facts relevant for its decision. So if there are doubts as to the fact finding of the lower court, the appellate court will engage in its own fact finding mission. Also, there is a restriction if you want to enter new means of challenge or defense. These are only admissible under limited circumstances if they concern an aspect that the court of first instance has recognizably failed to see or has held to be insignificant. Also, if they were not asserted in the proceedings before the court of first instance due to a defect of the proceedings, obviously if there was a mistake in the lower court while fact-finding, then you have to repair that on appeal. And also, if a party wants to add something new that wasn't part of the substance in the first instance, then it may enter this new information if it wasn't due to the negligence of the party to enter the information earlier. So this is, if you will, like a standard of negligence at this point. So in this respect, the appeal is on points of facts, on points of law, obviously, but also on facts under the limited exceptions I have mentioned.
Okay, I understand. Thank you so much. Then, Judge Yoon, how about in Korea?
Thank you. In our legal system, the appellate court is designed to continue the lower court case. Therefore, in principle, the procedures in the appellate court are similar to those in the first instance. However, some judges be stringent about accepting evidence submissions that could have been presented during their first trial, but were not. Especially, it's very challenging to reintroduce expert evaluations or witness testimonies that were already presented in the first instance, unless there are significant concerns about their credibility. Yeah, thank you.
Thank you, Judge Yoon. And then Judge Matsumoto, you have Federal Circuit in Washington, D.C. Would you share some practice in the Federal Circuit?
As we know, the Federal Circuit in Washington has exclusive jurisdiction to hear appeals from Article III courts, which are the district courts, and the United States Court of International Trade, and also may hear cases involving patent, trademark, registrations, and other subject matter from certain Article I courts, including but not limited to the United States Trademark Trial and Appeals Board, and the United States Patent Trial and Appeals Board, also known as PTAB, and the United States International Trade Commission. The review of the appellate court is limited to the evidentiary record of the lower court. So the Federal Circuit applies different standards of review for issues involving anticipation or obviousness, and that is because they review this as a matter of law versus fact. So anticipation is deemed a factual determination. That's Eli Lilly versus Zenith, decided in 2006. A patent is invalid as anticipated if the invention was described in a patent or published application before the invention by the patentee. And this means that the court is determining whether each element of a claimed invention is disclosed by a single prior art reference. For appeals on factual issues, the Federal Circuit applies either a substantial evidence standard of review or clearly erroneous, depending on the source, meaning what court decided this matter. When reviewing a decision from the PTAB, for example, the Federal Circuit will apply substantial evidence. This deferential standard asks the reviewing court to determine, quote, whether a reasonable fact finder could have arrived at the board's decision based on the available evidence. If the decision originates from a United States District Court, the Federal Circuit applies a clearly erroneous standard, which overturns the District Court's decision only if it is found to be clearly wrong. A finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire record of evidence is left with a definite and firm conviction that a mistake has been convicted. Did you want me to talk about the standards for review for legal issues?
If you want, please proceed.
All right, obviousness, by contrast, is considered a question of law with underlying factual determinations. So the reviewing court is asked to decide whether, in light of prior art, the claimed invention as a whole would have been obvious to a person of ordinary skill in the field at the time of the invention. Thus, the court reviews the factual underpinnings, such as scope and content of prior art, the level of ordinary skill, and the claim invention for clear error, but it also then reviews the district court's ultimate legal conclusion on obviousness de novo, meaning the appellate court can reevaluate that conclusion and decide it independently without deference to the lower court's decision.
Okay, thank you, Judge. And the standard of review might be different from bench trial and jury trial, right? If it goes with a bench trial, it might be reviewed by substantial evidence review standard, and if it is a jury trial, whether it is, if it is bench trial, it is whether there is some clear erroneous, and if it is jury trial, it is supported by substantial evidence, right?
When a fact finder, whether it's a jury or a judge in the federal district court, deference is given to credibility determinations and weighing of the evidence. So there's deference in that regard, and the appellate court generally is very reluctant to question credibility determinations by either a jury or a judge at a bench trial.
Okay, thank you so much. Actually, Germany, Japan, Korea belongs to similar countries, and United States is belong to commoner countries. So we have different two systems. So in the United States, the Federal Circuit review the cases in ex post manner, right? So I wonder whether the judges like it. The Federal Circuit judge and district judge might be different, right? How do you?
I think that as a district judge, of course you want to get it right, and of course you want to be correct on the law, and of course it's a little bit difficult to be reversed, but it is part of our job to do our best, and so litigants have a right to appeal, and they may seek further review of our decisions, and from time to time, not often, but sometimes the Federal Circuit will disagree and reverse. And that's fine.
Okay, recently I found that the reversal rate in IP High Court is a little bit higher than Federal Circuit because the difference of the system, right? As Judge Yoon mentioned, the parties can submit new evidence even in the appellate level, so will be similar in Japan, right, Judge Sugiura? All right, okay, well, we already finished the infringement litigation, and it means that we are over the hump. Now, let's talk about administrative revocation litigation. Start with overall system. Judge Yoon, will you start with the answer about this question? Please explain any systems or local rules adopted for efficiently handling the revocation appeals.
Yes, thank you. The IP High Court has established the guidelines not only for the civil appellate cases mentioned earlier, but also for revocation appeals. Then these are also posted on its website. The court issues an order to prepare for elucidation before hearings in revocation appeals as well. Parties generally follow the court's guidance of resulting in revocation appeals concluding after a single hearing. Notably, the IP High Court encourages the use of a presentation to facilitate efficient oral hearings as stated in Section 2.8 of the Guidance and Cooperation requested for trial proceedings. You can see the guidance on page 262 of the conference materials. In practice, most hearings involve oral arguments supported by PowerPoint presentations, which is significantly aid in understanding the case. To maintain efficiency and ensure fairness, the court inquiries about the time each party requires for their presentation before the hearing. A fair amount of time is then allocated to both sides, and a timer installed in the courtroom is used to strictly manage the allocated time. I think litigators often the pressure that taking timer like that, and right now, so do I. Looks like it's time for some mutual understanding. Yeah.
Sorry, Judge, interrupt you. You want to share this picture? Yes, there's some clock, time clock for,
That timer.
Was it the Chief Judge's idea?
Judge support the timer by budget.
Okay, thanks, Chief Judge. And what if the attorneys want to get more time for their presentation? So more time will be given, right?
Very difficult question.
You are not a presiding judge. Normally, what if the attorneys want to get more time because the case?
Presiding judges, I'm not presiding judges, so I can tell something difficult.
Okay, anyway, some additional time will be given to the parties, but for the same time will be given for both parties anyway. Okay,
Yes.
let's visit Germany. How about in?
No, I really like this time limit thought. This is amazing. I think this is something you share with the... Well, now the Federal Patent Court decides appeals against administrative decisions of the Patent Office. You remember that I talked about bifurcation earlier, so we have different venues for revocation and nullity on the one hand and infringement on the other hand. The appeal has to be submitted within 1 month after service of the administrative decision. Oral hearing is optional, no time limit, but written proceedings are the rule. The court, again, can set deadlines for statements of the parties, and on average, appeal proceedings last between 9 and 24 months. In nullity proceedings, the defendant can raise an opposition against the complaint within 2 months from service of the complaint, and the court shall indicate to the parties as early as possible those aspects which will presumably be of particular significance in respect of the decisions, or which are helpful for concentrating the oral proceedings upon the issues which are essential for the decision. And now I have to mention a new provision, because such indication is, as a rule, that's the wording of the provision, as a rule to be made within 6 months following service of the action. And this is a provision that you have to understand before the background of bifurcation, because as I pointed out, it is possible that infringement proceedings are on their way and actually overtaking revocation proceedings, which are not as fast as the infringement proceedings, because on average, infringement proceedings in first instance last for 1 year, maybe. And as I said before the Federal Patent Court, it can take up to 2 years for the revocation proceedings. So you have to deal with this thing that some people call the injunction gap, meaning that you might get an injunction on basis of a patent that later is being found invalid. And so what can you do about that? Well, I have to say the regional courts are very diligently in assessing the validity of patents, and they will only grant an injunction if they are of the opinion that it is more likely that the patent will hold than not. And also the Federal Patent Court, as I mentioned, is asked to issue a preliminary assessment within 6 months of filing the revocation action. This obviously is meant to speed up the revocation proceedings, but it also might help in the infringement proceedings, because the regional court has some assistance from Munich, right, telling them what the Federal Patent Court is thinking about the patent. So this is a quite important measure, and so I think on the whole, I mean, you won't be surprised by this assessment. On the whole, we are managing quite well as to the so-called injunction gap. Well, then again, the Federal Patent Court may set a time limit within the parties may submit final comments, and also extensions are possible. The average duration of nullity proceedings is also up to 24 months. Thank you.
Thank you, Judge. Actually, Germany is famous for its strict bifurcation system, and at the last year's International IP Court Conference, your colleague Judge Klein at the Munich District Court shared this amendment of adopting the preliminary assessment of the nullity case, right, from the Federal Patent Court. So I have some follow-up questions about this interesting system. How does it work in practice? I mean, the preliminary assessment of nullity case. Is it a actual binding to the judges, not just a recommendation? Then don't the judges feel burdensome about changing their preliminary assessment after hearing the case? And then one more thing is, doesn't it even make the judges hesitate to render a quick preliminary assessment?
Thank you. Now, first of all, I don't have statistics on me as to in how many cases the 6 months are met or not. But as I stated, the wording of the provision says that as a rule, you have to publish this assessment, this preliminary assessment, within 6 months. So there would be it would be required that there are some unusual circumstances that require longer time, more time. So I would assess that as a rule, usually you will get this assessment within 6 months. Now, to your second question about the, would the judges change their point of view? Are they feeling burdensome? And now please brace yourself, because I'm going to start preaching. And this...
Sorry, Judge, would you tell me that part again? Second question. Doesn't it even make the judges hesitate to render a quick preliminary assessment?
Now, I mean, the judges have to comply with the law, right? And so I would expect that they even if they they feel hesitant, they might have to overcome this feeling and issue the preliminary assessment. I have no doubt as to that they will be able to do that.
Okay, then one more follow-up question to make it more clearer. So what if there is some judge who does not render a preliminary assessment even until the deadline? What happens?
Actually, I'm not quite sure because this is so new, and I'm not familiar with cases where this hasn't been complied with. I think probably there will be no specific remedy for that because it's a procedural decision or procedural measure, in an ongoing trial. So I would expect that, this would not reflect well on the judge's practice, but probably there's no legal remedy for that. But I mean, I promised you to start preaching. May I do that? Because this refers to something that Judge Matsumoto has mentioned earlier. And I refer to your question whether judges feel uncomfortable changing their preliminary assessment. And I would say it is our professional duty to reflect on our own points of view and to evaluate them in the light of additional or new information at any time before rendering a judgment. So there should be no shame in correcting ourselves if we find that we made an erroneous assessment. Or that we have to modify our view in light of additional information.
Thank you, Judge. It is a new system, so you need more practice and precedent, right? And so please visit this conference next year with more practice.
I certainly will. Thank you.
Thank you. Let's move forward. And patent claim amendment is one of the really hot topic for patent litigation. Yes, let's visit Japan. Judge Sugiura. Question goes, does your country restrict or prohibit the filing of amendment to patent claims or the initiation of amendment proceedings during the revocation action against patent invalidity decision?
Thank you. Yes, the Patent Act provides on the requirements to correct claims, so the patentee cannot correct the claims during revocation action against patent invalidity decision. For example, as for the correction trial, a request for correction trial may not be filed between the time that a trial for patent invalidation becomes pending before the Japan Patent Office and the time the ruling on the trial decision becomes final and binding. Thank you.
Judge, I heard that restricting your claim amendment during the revocation appeal or trial is adopted in 2011. Is that right?
Yes. Exactly saying, a request for correction trial may not be filed between the time that a trial for patent invalidation, for example, is filed against JPO, and the time that the trial decision becomes final and binding. The duration may include the period that suit against trial decisions made by JPO is filed to IP High Court and its decision, judgment become final and binding. And the system is adopted by the 2011 Amendment of Patent Act, and one of the reasons is to solve this complicated situation. And before this amendment, in case that the correction trial is filed before JPO, while the court is dealing with suit against trial decisions by JPO, the court may send the case back to JPO. It was compared to catchball in baseball and criticized strongly. After this amendment, such harmful situation is resolved and proceedings of the trial for patent invalidation progress smoothly. Thank you.
Yes, actually in Korea, while we are hearing the case before IP High Court, the patent owner want to visit the PTO again and want to try to change their patent scope, right? So it is one of the cause of delay in our patent litigation. So can you tell us more about some changes after the amendment, like after adopting the new system, restricting the amendment?
It's completely changed the system. So it's quite difficult for me to explain the effect of the amendment based on the statistics or data. But I guess the strategy by patentee as complaint, plaintiff will be changed because as you may know, Japan adopt it's called the double track system. It means the patent invalidity process against JPO and the IP High Court, and the patent infringement litigation are running simultaneously in some cases. So the patentee as plaintiff make a strategy when or whether they request the patent claim correction of claim, and or they don't file to claim of correction, but in the patent infringement litigation, they allege as a rebuttal against the defense of invalidity by defendant. It's the the patentee can select the way to struggle between the defendant. Thank you.
Let me make it clear about this point. So while some litigation is pending before the trial about the revocation case, can the patentee visit the Japan's patent office again to amend their claim? It is not, right? During the revocation litigation, to initiate their new claim to amend their claim.
During the revocation of the patent invalidation, the patentee have chance or opportunity to correct the claim when JPO informed their preliminary decision about the invalidity of the patent. In order to respond to such a decision, the patentee can correct the claim.
So it'll be announced in advance. It might be invalidated. So yeah, Japanese system sounds sophisticated. So let's study more. Okay, Judge Matsumoto, would you just briefly explain some reissue practice, just briefly? Reissue practice. I know the United States reissue is used for correcting the claims scope, right?
Well, I think what the system wants to avoid is duplication of efforts and expense by the parties and by the adjudicating body. So in the district court, we can stay our proceedings while a party seeks review. That stay decision is immediately appealable to the Federal Circuit. And during administrative review of patent claims, patent amendments are governed by 35 U.S. Code Section 316D, which allows for one motion to amend, so long as the amendment does not enlarge the scope of the claims of the patent or introduce new matter. If the motion is accepted, the amended claims are to be assessed for patentability alongside the original instituted claims during the proceeding. Now, amended claims are entered into the inter partes review, but not into the patent itself. The patent owner does not bear the burden of persuasion on patentability in motions to amend during the revocation proceeding. However, the board can rely on provisions such as 35 U.S. Code Section 112 to deny motions to amend the patent claims. During a revocation action concerning a patent validity decision in PTAB, the American Invents Act provides that a patent holder may amend again as long as they do not enlarge the scope of the claims of the patent or introduce new matter. Now, thank you. I don't know if that addresses your specific question, Your Honor.
Okay, thank you, Your Honor. I think in the United States, the reissue is a little bit widely allowed, right? Seems like that. Okay, thank you. I think we are approaching the last hill. This estoppel is very difficult topic. The question goes first to Judge Feddersen. Is it okay, Judge Feddersen? Last hill for you? Okay. Please explain any system in your country applying the principle of estoppel to ensure efficient and cost-effective litigation proceedings. And one more. Specifically, in the infringement litigation involving the same patent, can the patentee present claim construction arguments that contradict his or her previous assertions, or which had been made during the patent filing, patent appeals, or other civil litigations? Would you answer?
I'll try, thank you. To your first question, there is no doctrine of estoppel in German procedural law. However, according to Article 138 of the Civil Procedural Code, the parties are to make their declarations as to the facts and circumstances fully and completely, and are obliged to tell the truth, surprisingly. Furthermore, parties to court proceedings are bound by the civil legal obligation to perform according to the requirements of good faith, which may be violated by contradictory behavior. Thus, a party may, and also may be obliged to, specify, complete, or correct prior statements. And if that happens, contradictory statements of a party are not automatically deemed irrelevant. Rather, pursuant to Article 286 of our procedural code, the court is to decide at its discretion and conviction whether an allegation as to fact is to be deemed true or untrue. Therefore, it is standing case law that the court has to exercise discretion as to whether it regards a statement of a party that contradicts prior statements as true or untrue. And I was just about to answer the second question. This is specifically like a patent, patent law issue. The Federal Court of Justice has indeed decided that a patent holder cannot claim infringement of a patent if in opposition proceedings he has disclaimed protection of the now contested embodiment produced by a party of the opposition proceedings, because this behavior violates the obligation to perform according to the requirements of good faith that I mentioned before as a general civil legal principle. Thank you.
Thank you, Judge. And it falls under the discretion of the court whether to apply that principle or not.
Correct.
Okay, how about in Japan, Judge Sugiura?
Thank you. In Japan, the principle of estoppel is understood as one of the expressions of principle of good faith, and the Civil Procedure Code provides it as a general principle. Therefore, if an action by party in civil litigation procedure has violated the principle of estoppel, the court may dismiss it or deal with it as invalid action or deny the effectiveness. There are no laws to provide about the principle of estoppel about claim construction. However, it is a common understanding related to the patent infringement litigation as well as the litigations against JPO's decision that the prosecution history of the patent should be considered when claim construction is implemented. Of course, file wrapper estoppel is considered as a matter of course. Thank you.
Thank you, Judge. Then it sounds similar to Germany's system. Okay, thank you. And then how about in the United States, Judge Matsumoto?
Well, we have different kinds of estoppel with the overarching goal of preventing parties from relitigating the same issue more than once. So judicial estoppel is a more, I guess, akin to the district courts, the trial courts, where you cannot take a position contrary to a position you've taken in the same litigation or in an earlier legal proceeding. Collateral estoppel or issue preclusion prevents a party from relitigating an issue previously resolved in a lawsuit or in an administrative proceeding, even if the issue relates to a different claim. Any party may assert collateral estoppel, and it would apply only when the party against whom collateral estoppel is asserted had a full and fair opportunity to litigate the issue previously. Also in the United States, courts recognize res judicata or claim preclusion and collateral estoppel issue preclusion, which again avoids relitigation of the same claim. The Federal Circuit has held that collateral estoppel applies in patent cases when the defendant had a full and fair opportunity to litigate the issue was actually litigated, and the controlling facts and applicable legal rules were the same in both actions, and resolution of the particular issue was essential to the final judgment in the first action, and the identical issue was decided in the first action. The U.S. Congress has also created inter partes review specific estoppel, which is conducted by the Patent Trial and Appeal Board in 35 U.S. Code Section 315. The petitioner in an inter partes review of a claim in a patent under this chapter that results in a final written decision may not assert either in a civil action or in a proceeding before the International Trade Commission that the claim is invalid on any ground that the petitioner raised or reasonably could have raised during inter partes review. So those are concepts, again, to avoid duplication and expense.
Thank you, Judge. Not only have been raised, but also could have been raised, right? The Peter estoppel applies. Okay, in the United States, you have judicial estoppel, collateral estoppel, claim estoppel, claim estoppel and Peter estoppel. I think in the United States, estoppel works as a very strongest framework to make the process very effective, right? Is that right?
It's an equitable doctrine, and in the United States, we value the concept of finality. You know, the parties have spent money and time litigating a matter in whatever form they choose. Once an adjudicator makes a decision, the idea is finality. And of course, they have appellate rights, but we don't want somebody coming back and forum shopping and bringing the same claims over and over again.
It sounds good. Then this estoppel defense often raised and well granted? will be successful with this defense, estoppel defense?
It is raised, and at least district courts, and I believe the PTAB and the Federal Circuit would look at this issue and either uphold the lower court's decision or find that it wasn't barred.
Okay, thank you, Judge. Finally, we reached this final question, hypothetical question among the judges. Okay, today, during this session, we discussed various systems to make our process efficient, right? So among all the litigation systems discussed today, which one would you like to bring with you in your suitcase to make your jurisdiction more attractive? Who will go first? Anybody?
May I?
Yes, you may.
Thank you very much. If I may, I would like to propose a mixture of all the three neighboring systems that I have learned about today. So first of all, and we have talked about this before, but it is not only because of the wonderful presentation of Judge Matsumoto, but also because I have seen so many fantastic Hollywood court dramas. I really dream of the option to render orders of complaint of court, right? This is what we all dream about outside of the US. Secondly, and maybe a bit more seriously, I really like the idea that I heard from Judge Segura today about technical assistance of patent courts. And I'd like to refer to the speech of Judge Jordan from yesterday, and would politely ask for admittance to the camp of Justice Scalia, at least in this respect, because unfortunately I do not have a pharmaceutical background as the very impressive colleague from Korea yesterday, for example. I'm not a technician and I'm not a physicist, so I really would appreciate technical assistance if I imagine myself deciding a technical, upon a technical patent. And thirdly, and I think I have mentioned that already, I also like the idea of time limits. Even before the European Court of Justice, the parties have page limits. So if you want to render your claim, you have to. I think you have 15 pages, and you have to really be brief and very concise. So I also like the idea of time limits, which I also have witnessed in front of as a spectator in front of the U.S. Supreme Court. I think each side has 30 minutes, and this is mercilessly enforced. So these are the three elements that I really like and would take with me in my suitcase if customs would allow it. Thank you very much.
Would you give him a big applause? Thank you, Judge, but I think your suitcase might be full, right?
How do you know?
Who will be the next? Okay, Judge Yoon.
Honestly, I couldn't pick just one, but I can share one appealing system from each country that caught my attention. In the US, definitely strong and specific sanctions imposed by courts enhance the efficiency of proceedings. I don't know how did the litigators sort of think about that. In Germany, I was impressed by the strict penalties, including fines or even detention, imposed for violations of inspection orders. Japan's regulation, which restricts claim amendments during revocation actions challenging patent invalidity decision, is also a mechanism I feel is necessary to consider for adoption in our system. Yeah, thank you.
Thank you, Judge. I think you already found many things to make our IP High Court more attractive, right, in this session. Okay, thank you. Who will be the next? Okay. Oh, sorry. He was faster.
Thank you. Actually, I myself faced the difficulty to correct the evidence concerning the calculation of damage. In some cases, the defendant strongly resist to disclose their financial documents, but the system I introduced this session, I think it's still not function sufficiently. So I'm very interested in the way to collect such documents among these countries. Thank you.
Thank you, Judge. Thank you for sharing your good experience and opinion. Yeah, the heroine comes to last, right? Judge Matsumoto.
Well, like Judge Feddersen, as I said at the beginning, we are courts of general jurisdiction, and I am not a science, engineering, technology person. That makes our job very interesting, but also more challenging, and I would welcome more technical help. And I think that there's something to be said for specialized courts. So for example, when Judge Cheney yesterday described the fact that he has people on his court with engineering backgrounds, I think that's wonderful, because I had a case involving retractable roofs over stadiums, and there were principles of engineering and physics that were very difficult for me to grasp. I do commend the lawyers who practice in this area, because their job is to teach the judges about the technology, and I think they do an excellent job. I also appreciate the fact that there doesn't seem to be this parallel proceeding in other countries where a court may be devoting a lot of time and resources to resolving a dispute, but meanwhile there's an administrative proceeding that may invalidate the patent and render our work and our jobs null and void. So it's a very inefficient situation, and I think the American Invents Act is trying to address some of these inefficiencies.
Thank you, Judge, so much. Okay. Now it's time to open the floor. Okay, I'd like to welcome one or two gentlemen or lady. Okay, over there, the first. Yes, in the middle. Sorry. Next.
Thank you. Thank you all for sharing your insights. My name is Jung Eun-yoon. I am the judge of IP High Court of Korea. And I have questions for Judge Matsumoto from United States and Judge Feddersen from Germany. I think I feel similar difficulties when assessing damages in my cases with Judge Sugiura. So in Korea, there is a currently ongoing issues, discussion about improving evidence collection procedure system, focusing on the finding some balanced approach between United States and Germany. So here's my question. To best knowledge of mine, I know there are some several discovery tools in the United States in civil cases. So what is the most powerful and strongest discovery tool in the patent infringement cases in the United States? And for the Federation, the Article 143 of the German Patent Act, I know that this article is the distinctive tool from the general civil cases. And so I'm wondering that how often is this applied to actual cases? Thank you.
Thank you, Judge.
I think that all of the discovery tools used together can be very effective. Usually at the beginning, there's automatic disclosures that must be made by a party, both parties in a litigation. The least expensive discovery tool is interrogatories, meaning asking written questions to be answered. Also requests for admissions, where a party can ask a plaintiff or a defendant to admit certain facts or to identify or admit that these are your contentions or your defenses. The third is documents, which can be expensive if they are voluminous. There are tools that one can use in discovery to search and sort documents. There's also, as Judge Feddersen was explaining, an ability to examine the infringing object. And many times issues of secrecy or confidentiality will arise. A judge can impose a protective order where the parties agree to be bound to not disclose information they learn. The only issue that arises that complicates things is ultimately when a judge makes a decision on a matter, it might have to use some of that protected information. And that becomes what we call a judicial fact. So if a judge needs to rely on certain factual information to render an intelligible, understandable decision that explains his or her reasoning, the court will usually tell the parties, look, these are important facts that are going to be fundamental to my decision, and in order for my decision to have any use to beyond the parties to the litigation, certain facts may have to be disclosed. And I think Judge Jordan was explaining his procedure, which makes a lot of sense, which is to give notice to the parties that certain facts may have to be revealed. So, and the last tool, which is the most expensive, is to take a sworn deposition under oath of a witness. And any lawyer who's evaluating the case wants to assess how that witness is going to hold up. What kind of impression will that witness make to the fact finder? And does that witness know what he or she is talking about? Or are they avoiding disclosing all the information that there might be?
So, Judge, follow question goes, and then if you are obliged to choose just one thing, the strongest one, which will be that?
When I was practicing law, I liked to do the depositions because then I know what kind of witness I'm dealing with, and I know whether that witness can be weakened on cross-examination. I know what their vulnerabilities are, and you've locked in the witness on their testimony. If they don't remember anything, then they're not going to remember anything when it comes time to present the case to the finder of fact. And so it gives a lawyer a sense of that witness, and that is an important assessment.
Thank you, Your Honor, that position. Okay. Then Sugiura, are you ready to answer the second question? Okay, Judge Fedder, sorry.
No problem. Please go ahead. Now, your question concerned Article 146 of the German Patent Act, and I would like to familiarize myself and you with this provision, which says any person who uses a designation on items or on their packaging, which is likely to create the impression that the items concerned are protected by a patent or a patent application, is obliged on demand to provide information regarding the patent or the patent application. So this is basically a right to information. This is the one you were asking about, right? (146).
140C, you're talking about. Judge Yun, 140C, what is about?
Yeah, I think.
I'm sorry, please understand I'm not familiar with German Act, so I might be wrong. But to my best knowledge of mine, 140C is about the make the law the likelihood of evidence to if parties want to get evidence, they have to show some likelihood. In civil cases, they require the higher likelihood, but in Patent Act, it says that you can get evidence even if you have a little bit lower likelihood. Is that correct?
Judge, are you ready?
I'm always ready. Now, I would say that the usual standard of probability of infringement would apply as well here. So you have to the like the court has to come to the opinion that that an infringement is the case, and I think it will apply like the usual standard of that we apply in other civil litigation as well. So I'm not sure whether this answer is really helpful, but this is.
Okay, let's leave it there. And then Judge Sugiura, there was no more question to Judge Sugiura? Okay. I'm sorry, but just only I will take easy question because we are almost there. Yeah, very easy, Judge Kalden. Easy and simple.
Okay, I'm Rian Calden. I'm with the Unified Patent Court. For
Whom are you asking?
Yes, for our German colleague. You were saying there is a good faith principle under German law that if a party makes a certain sort of disclaimer during opposition, he cannot rely on whatever he's disclaimed during the proceedings. How do you reconcile this with the prohibition in Germany to actually look at the prosecution file at all during proceedings?
Well, I think as to this decision, that's the Datengenerator decision that I was talking about. It is about holding the patent holder to the standard of good faith and to prohibit contradictory action in that respect. So. We would probably regard that as an exclusion, as a special situation where you would, in fact, consider the history of the patent.
Okay, thank you. Follow up?
I'm sorry, I don't understand this, how you can reconcile this, because the whole point of looking at the prosecution file during infringement proceedings is about legal certainty of third parties, which is actually in the protocol. So I really don't understand the difference between looking at the prosecution file and see what the patentee has said about the scope of claim that he's invoking and your principle of good faith, while at the same time prohibiting a party to invoking the prosecution file during proceedings.
Now, maybe this is a very special situation where we are looking at assertions or waivers that the patent holder has made in relation to a party of opposition proceedings. So maybe this is it's like a special situation because there is a special tie of good faith, if you will, between the two parties of the litigation procedure. Maybe that is the reason why we would, draw that distinction at this point.
Okay, so it only applies for the party who was actually a party in opposition proceedings himself.
That is how I read this decision, correct.
Okay, I can find many other persons who want to raise your hands, but we are at the same venue, and then you can continue after this session. It's time to wrap up, I'm sorry. It was a very intensive and fruitful discussion, right? I really appreciate all the judges' eager participation, and I also hope the audience really enjoyed this session a lot. Did you? Oh, thank you. I heard yes. And judges, now you are all dismissed from the long session. Thank you all. Thank you.
감사합니다. 이것으로 네 번째 세션을
Thank you. This concludes the fourth session.
연사분들과
Thank you so much for the panelists and also the moderator.
점심
you. you. you.
곧 특별 세션을 진행하겠습니다.
Ladies and
참가자분들께서는 모두 입장하시어 자리에 착석해 주시기
We will-
바랍니다. The ball will begin shortly. We kindly ask everyone to take your seats. 즐거운 점심 시간 되셨는지요? 이제
If you enjoyed your lunch, we'll now start with the special session. We will look into the growth of the IP litigation process. Will be moderated by partner Yoo Kim of Liengo, with other litigators taking the panelist position. Please welcome them all with one round of applause.
I'm very honored to host this special session. To my understanding, this session is planned to give opinions about how to improve current court system, and some judges might be uncomfortable and but I hope this session will give good advice about the current system, and our judges would be welcoming and open-minded to accept some advices. Yeah. Before starting this session, I would like to introduce myself. I am Uno Kim, and I am the partner of Liengo, and I am currently the president of Korean Intellectual Property Lawyers Association. I want to give a simple explanation about the KIPLA. In abbreviation, KIPLA, we call it KIPLA. KIPLA is an association consists of 1,000 IP lawyers who are dedicated to protect IP rights and promote innovation. And our association, KIPLA, have a strong ties with other counterparty in other jurisdictions. And one example is EPLO, European Patent Lawyers Association, and Japanese IP Lawyers Association. And we are planning to host foreign exchange conference in Seoul next year with IPNet, Japanese IP Lawyers Association. And so please I request, give sincere attention to next conference in Seoul. Yeah. I would like to introduce our esteemed guest speakers today. The first speaker is Gun-taek Soo. Please give him a big hand. He is the partner at Beckham & Lee, and he was a founding members of Korean patent law, and he was the first president of KIPLA. And second speaker is Lee Sung-ho. Please give him a big hand. He is of counsel of Yun and Yang Korean law firm, and he was a chief presiding judge of patent court, and he served Korean Human Rights Commission as a commissioner. Our third speaker is Chae Sung-jun. He is managing partner of Kim Jang-en Lee, and he served founding members of Korean Patent Court, and he served as a Korean Communication Commission as a commissioner. Our last speaker is Han Sang-uk. He is a senior attorney of Kim and Jang, and he is known as a leading IP lawyers in Korea. Let me start first from Gon-taek-soo. He will explain about the Korean preliminary injunction and injunction system. And I will say, please understand, from this time on, we will proceed the procedure in Korean, and please use the simultaneous interpretation system to understand.
지금 소개받은 권택수 변호사입니다.
Hello, this is Kwon-taek-soo as introduced. The topic that I will cover today is the enhancing the injunction framework, development of preliminary and permanent injunctions. Well, but this is after lunch, so I will try to be as fun as possible. Not sure if I'm equipped to do that, but I will try my best. Then I will proceed with my presentation. So the overview, as you are well aware, the injunction is stipulated in the Patent Act, Article 126.1. And the Korean case law consider it as a right that is similar to the property right claim. And when it comes to the current status, there are damages claims and the injunction claims, and there are cases where the party would claim for both, and there are cases where the party would be claiming only one at a time. So including the ones that the two are pursued at the same time, about 80% of the whole claims are related to the injunction. And I think as for the preliminary injunction, I can just skip that page. And let me tell you about the current status with regard to the preliminary injunction. Well, we are seeing that the number of cases is decreasing, but still it is very well used. And there are cases where the preliminary injunction is pursued even without or before the case on the merits is pursued. And moving on to the main point, which is around the prospective analysis of permanent injunction litigation practice. So in most cases, not sure how this will sound, but we think that the patent infringement is more related, very much equals the injunction. That is something that is considered in practice. And this direction that the legal practice has been taking so far, is that really the right way to go? That is the question that I would like to pose through this presentation. So there are, of course, positive aspects to the injunction, permanent injunction. with the permanent injunction, you can strengthen the position of the patentee by applying the direct sanctions, and there are the aspect of providing remedies for harm beyond monetary compensation, and this is also enhancing the negotiation and dispute resolution amongst parties. But then there are also the downside to it, which is that this is actually creating some tension against the Patent Act, which is trying to promote the innovation and the use of innovation. And this can also be misused as a means to maximize the profit even beyond the recovery of the damages. And also, it can actually cause excessive harm that is unexpected to the infringer. So we need to think deeply about the function and the role of the permanent injunction. The eBay decision is something that you must be very well aware, so I will just skip this page. And as for the next one, I have created a table on what other jurisdictions are doing. You can refer to it in the booklet. I'll skip this page. And I would like to now touch upon the nature of the permanent injunction. So property rights claim is the very general theory that is accepted by most of the academia, and I think there's not much of a disagreement related to it. So this is part of the property right claim and something similar to it. Of course, the direct tort approach and also the effect of the Patent Act kind of an approach is something that is considered as part of the academia, but this is not the mainstream. And we also need to look at the purpose of the Patent Act alongside the permanent injunction. So that is why I put it on the right-hand side of the screen. So the patent scheme is having the purpose of promoting the industrial development, and this is the right which is a means to this end, and this is not an end in and of itself. So when you put it differently, so the permanent injunction does exist for the purpose of reaching the end, and it is not the end in and of itself. So it will need to live up to or meet with the initial purpose of the patent right and the patent scheme. So we will always need to think about whether there is a need to balance the right to the permanent injunction in light of the purpose of the patent scheme. So we will need to consider the following aspects. I have actually prepared 6 different factors that we will need to consider. The first one is the question of whether the patent is practiced. I mean, the patentee, if they are not practicing the patent, and is it really still necessary to protect the patent right then? And the second point that I want to touch upon is the possibility of monetary compensation or monetary damages compensation. I mean, if that can be pursued, do we really have to acknowledge the permanent injunction? And the third factor that we need to consider is the intention of the patentee. If the patentee is using this as a leverage in the negotiation to achieve an excessive return, then we will have to be cautious about it. And the fourth factor that we need to consider is the existence of a competitive relationship. If there is a competitor to the patentee, we will need to consider that aspect when we are thinking about the permanent injunction. That is another factor that I think should be considered. And the fifth factor is the effect of rights. The possibility of the patent being invalid and the remaining life of the patent shouldn't it be considered alongside the other factors. And the sixth factor is the public interest, the market demand and the consumers' interest and the public interest. Maybe we need to consider those aspects when we are considering the permanent injunction. And when we are considering all these 6 factors, would we still come to the conclusion that the patent infringement claim equals the injunction claim? Is this direction something that is really okay? Shouldn't we change our direction a bit considering these 6 different factors? This is the question I would like to pose to you. And based on this, I would like to suggest about 10 hypothetical cases where we will need to balance the permanent injunction. The first case is that only a part of the product has an infringing element. Should we apply permanent injunction even in this case? And the contribution of the infringing product or the part, if that is low, what should we do? And if the infringement of a certain patent of a certain part, if that is leading to the suspension of the production of the whole product, shouldn't we consider that aspect as well? And in practice, in this kind of a case, when only a part of the product is infringing, then if possible, we would be only disposing of that part, that infringing part. And if it is not divisible, then it will be considered as part of the whole. And the second scenario is infringement done in good faith. Based on the patent contract, the licensee receives a certain product, and there could be a case where the licensee received the infringing product, and in that case, that licensee would be bearing the losses, and in that case, I mean, should that person be considered infringing too? There are requirements that are stipulated, but still, even if that is there, even if the infringer is doing it in good faith, shouldn't we consider that? I mean, our consistent view is that for this type of an aspect, I mean, even the negligent party will need to still bear the responsibility, but there is still a stipulation in other cases that the percentage or the proportional application is possible, but then for the permanent injunction is not possible, so maybe we will need to consider that aspect. And the third hypothetical case is where the patent has a possibility of being invalidated. Should we still acknowledge the permanent injunction in this case? I mean, the abuse of rights could be a way of defense, of course, but when it comes to the invalidity grounds, I mean, of course, this is related to the preliminary injunction as well, but this is actually delaying the hearing process, overall procedures, so we will need to think about this aspect more deeply. And the fourth hypothetical case is related to the NPE, a so-called patent troll. If they are exercising the permanent injunction claim right to pursue profit, is it still something that we will need to consider? There are cases where the foreign companies pursue the permanent injunction cases in Korea and against Korean company. Shouldn't we consider that aspect? I mean, there were 321 cases, such cases so far, and these kind of suits that are pursued by the MPA, should we continue to allow it? And I also prepared other 5 different hypothetical cases. The fifth one is related to the technical standards. I mean, for example, if the technology is used for the standardization and the permanent injunction is pursued against it, should it be also granted? And when it comes to for example, the sixth factor, if the patentee does not have any intention of practicing or implementing the patent, should it still be acknowledging the permanent injunction? And the seventh aspect, when the permanent injunction is becoming the hurdle to the technological development, should we acknowledge it? And this eighth one, which is related to the public interest, the patents that have a high relationship with the public interest, should we consider that? And the ninth factor is around the exercise of permanent injunction colliding or being in conflict with the other laws legal interest. For example, when it comes to the Fair Trade Act, there could be the legal interest conflict, and should we still acknowledge the permanent injunction right? So I have given you about 9 different examples here, but maybe the 5th factor that is related to the technical standard, I mean, we saw it in the Apple v. Samsung case, which related to this patent. There was a decision on that aspect from the Korean court. And the DSBU preliminary injunction case, I mean, that was dismissed in Japan as well, and we do have to consider those aspects. And the last one, the 9th factor, which is related to the Fair Trade Act. Recently, the KFTC, I think, has made a notification that it will be making modifications to the enforcement. If there is a patent infringement lawsuit with the intention of misusing it, then this would be considered unlawful. That is included. That is, notified to be included in the new revised guideline or the enforcement rule that the KFTC has. So we will need to wait and see how it unfolds. And the other part related to the equity between the patentee and the infringer, this I think you can refer to it from the back booklet. And then let me move on to the 3rd point, which is to diversification, which is related to the diversification of permanent injunction types. So when it is infringing, then we are giving injunction. I mean, that is what is done in practice. And in light of that practice, I am not sure whether it will be possible to allow multiple variations of the permanent injunctions, but I really hope that you will give a thought about this. So when it comes to the prohibition of practicing patents in certain manners during production, use, transfer, lease, or import, maybe we can consider this. Maybe we can acknowledge a wider discretion by the judges in the cases that is laid out here. And next is the preliminary injunction, but this is something that you are very well aware of. But when it comes to the preliminary injunction, this is actually very much becoming like a litigation on the merits. So when it comes to its benefit of being a speedy process, it is being undermined these days. But if the result of and there are many cases where the injunction decisions are affecting the litigation decisions, so that will need to be thought out very deeply. So that's one comment that I would like to leave about this one. And moving on, when it comes to the preserved rights, well, the balancing is needed, as I said earlier. And there was a decision made by the Japanese IP High Court, and this is the Samsung v. Apple case. And in that case, there was a case where the case was dismissed without prejudice because it constituted abuse of rights. And these, I think you are already aware of this, so I will just skip this. And the security deposit, I think I can skip this as well. And the most important or debated aspect is around the invalidity decision. When there is an invalidity decision pending, then the injunction decision comes late. And there are cases where the injunction decision waits until the invalidity results comes out, so that causes delay. So in that aspect, maybe having an patent office's measures in place so that we can lower the percentage of the patent invalidity is something that we will need to consider too. And The stay of enforcement of a preliminary injunction, this is not something that is really acknowledged in practice, but we will need to once again think about this aspect. I will skip this part, revocation, and the integration or decentralization of the jurisdiction is really important. And now the appeal is actually centralized. But then when it comes to the preliminary injunction, the injunction appeal still goes to the High Court, so it is scattered across the country. So this is something that the legislative effort will need to focus on, so that such injunction appeals are also centralized. And due to time constraint, I think I had to rush a little bit, but what I want to say is that regardless of it being the permanent injunction or the preliminary injunction, patent infringement equals the acknowledgement of the preliminary injunction is the direction that we are taking in Korean courts now, and I really hope you to think deeply about this and reflect on this and whether this is really the right way to go. Thank you.
Thank you for your presentation. He will give some advice on the damage system in Korea.
안녕하세요.
Good afternoon. Well, we have Chief honorable judges from IP area, so to be able to deliver this presentation in front of you, it's really an honor. I've been lawyer not that long, so still, if I dream, I don't dream as a lawyer, but actually as a judge, where I have to settle things, although I wasn't grasp the core of the issues at hand in various cases, in a case, and also in preparing this presentation in 1998, 26 years ago, before actually opening the IP court of High Court of Korea, I actually created committees to create the laws and regulations governing over the IP proceedings and other things that I did for the establishment of IP court become reminiscent of them. So when it comes to judicial practice and also academic research in the IP was actually facilitated through the establishment of IP High Court, and as a specialized court, IP court was able to protect IP rights. There's also promoting more investment from overseas. So I'm really glad to see that we have done the right thing, and I express my respect to those that followed in that footstep and are still working hard even this day at the IP court system. So today I'm going to talk about directive improvement of damage litigation, and academically it's not that difficult area, and probably the content-wise you already know. So it's kind of a reminder. So not as an attorney, maybe I'm telling you this as kind of a judge that a senior judge that went before you. Now I'm going to talk about enhanced case management, concentrated hearing, effective evidence collection, and how we can calculate damages. So I'm going to focus mostly on these three areas in my presentation. So in the introduction part, what I want to emphasize is that IP High Court is a specialized court. So if you think about people coming from other cities to Daejeon, and, the hearings at the IP court needs to be done in a concentrated manner, but to allow them, not only does the IP High court do its job faithfully, even from the first instant court, it ensure more thorough hearings. And when you do practice as laws, document collection order things sometimes are not that effective. So there are still issues in terms of evidence collection, in terms of calculation damages as a result. It's not. It's mostly discretionary basis rather than based on exact numbers or grounds. Hence, by having more effective evidence and facts, I think that would also be inducive in terms of having more effective damage calculation. That will be kind of the overall view of my presentation. Now, when it comes to issues related to patent litigation, in terms of case management, there is a lack of proactiveness. And in the appellate hearings, like in the first instant hearings, there is a lot of repetitions, looking over the same things which we already did at the first instant court. So looking back at my experience as lawyer, judge as two, in the U.S., they amended, civil procedure rules in '93, and also civil procedures were amended in '96 in Japan. So in terms of the role of judge, they went further from just becoming mediator that was neutral. They actually assigned the role of having become more a proactive case manager. So I believe, Korea has done also some things, but mostly, and I also should have done better in that area, but was rather passive role as a judge, more as a, judging things rather than being proactive in intervention, and that's maybe hindered a more proactive review cases from the first instance court. And because of that, even the appellate court of the IP High Court, you still have to look and go through the evidence there, thereby delaying the process. Hence, ultimately, then, how can you calculate the damages? First, let's look at how the U.S. and Japan has done, because they amended the rules before us, and maybe we could at least learn from what they did right. And in that context, let me introduce, here there's an introduction of the U.S. and Japanese legal system. In the U.S., when it comes to case management portion, the pre-trial conference and discovery, that will be the portion related to that. Now, pre-trial conference is very similar to our preparation process, so I'll just skip that part. So in the pre-trial conference, it's a bit same or similar to ours. And then in terms of discovery system, that is the biggest difference from the Korean regime. And of the discovery system, what I would like to particularly bring your attention to is that between the parties, the first initial disclosure process. So this initial disclosure, in the federal rules, it did not exist, but in amendment of the 1960s was actually included. So when it comes to infringement-related damage litigation, at the beginning of the filing of the lawsuit, plaintiff first need to disclose will be the base grounds for damage calculation. So based on the evidence it proposes the damage, and related evidence document used for such a calculation needs to be submitted in automatically. So that is the interesting point. And if you look at also various guidelines and manuals in terms of patent proceedings, this has been emphasized. So in the beginning, the court, what is the size of the case? How should we approach this? And in terms of the amount, they need to like roughly have a estimation of the possible damage to assess whether there's any possibility settlement and what should be the schedule of the proceedings. And because of that, I think the key is that plaintiff give you disclose everything that you have. But do we have the same kind of approach in Korea? Well, we do have similar thing in the Article 246 of the Civil Proceedings Act, and it says that we need to specify, your evidence, and you also need to submit all the related documents. So this means that the plaintiff files a case, then it also means you have to disclose everything you have. It's not like we cannot argue for something not before the defendant gives us the information. So we don't wait for that. So it also, in the same Act, Article 146 also says all the evidence and information needs to be submitted. And based on that, or if the damage calculation related information is all submitted from the get-go, you could sort of manage the case, foresee what should be the schedule, and based on the size involved, you could be more inducive toward going a settlement and in other alternative resolution approaches. So not for appellate, but at least for the first instance, if they do this part well, I think it would increase efficiency. In terms of violations of the documents of production, there are various penalties involved. For example, like you can dismiss the case, or you could let the other violating party bear the litigation cost. So if they violate the order for document production, we could also have similar penalty process as they do in U.S. Next is the Japanese system. And due to time frame, I think I need to be fast. But here it says in 96, for concentrated hearing process, they amended the rules, and they also amended the rule after that once again 2003 for expedition purposes, and based on that, different systems have been introduced. Now in Korea, we also introduced some of the systems, but in practical sense, it's not really being widely used. Hence, it didn't really result in material changes in our hearing and proceedings. That's my opinion. And you have pre-filing inquiry system and pre-filing evidence collection disposition system in Japan that's been newly added, and also issue identification procedure, very similar to our process. Now, planned hearings. Now, it's a complicated case when you have to determine damages on infringement. And for such cases, planned hearings is mandatory and something that we could take note of to maybe have in Korea. And also appraisal calculation of damages. In case of Korea, plaintiff or defendant actually ask 6 expert opinion and just submit that as a but whether there has can be if the power as evidence is doubtful, so maybe we could also learn from this calculation damages system. And in other countries, when it comes to IP lawsuits, mediation, arbitration are actively being used. So that is the part I believe is most lacking in our judicial practice. practice of Korea. So in case of Korea, for first 61% of first instance civil cases resolved through settlement. In the table, even only in IP cases, 53.33% go settle. And I went to the website of Japanese system and look at the centralized mediation division and looks over all the mediation and it settles through all cases 60% and takes very short time to do that. And in U.S., more than 90% of IP cases are settled. But in case of Korea, it's less than 15% also. So this is part where we can do better, I believe. So all judges have to write the judgment, and it takes a lot of time to write it up. So actually, you cannot therefore invest a lot of time in terms of hearing and looking at the evidence, which is regrettable. Now, it does some conclusions, but I do believe I covered most of them, and due to time constraint, I need to skip this part. Effective evidence collection system. Well, for Korea, document collection production orders are in place, but there are many cases where the litigant do not comply, and that also do not result in effective sanctions, which is also a problem. And also in-camera procedure, how can we utilize that and improve upon that? We do have in-camera procedure. However, in terms of mandatory document production, we could do more, and also in camera procedure, allowing the legal representatives to take part or expert to take part is something we could do because it exists in other countries but not in Korea. So we need to just go through the slides. Now, in terms of document production, if there's non-compliance, I talk about having effective sanctions, and in calculating damage, that should also be reflected. And lastly, I'm going to talk about the appropriate calculation of damages. Now, even this collection system is not really effective, so damage calculation in terms of it's rare. It's based on the substantiated loss calculation, but it's actually done at discretion of the court, so it actually estimated in most cases. So in Korea, punitive damage is not really done. So that means you're forced to pay damage. And even if you fail in the first instance, you could actually ask for suspension and continue with your litigations. So it's better to continue with the infringing. You can actually continue with the infringement act if you play the system very well. So I think punitive damage system, needs to be boldly adopted to discourage such abusive system. But anyway, again, from the first instance, case management needs to be done more better. I was asked to talk about damage calculation. So, plaintiff proposes damages and related evidence and use that for early settlement or for planned hearing would be better. And for, document production order, if they don't comply, more sanction needs to be in place. And also damage calculation needs to be in place. That will be my three conclusions. Thank you very much.
Thank you for your presentation. The presentation include even other jurisdiction statistics. It's very inclusive. Thank you. The next speaker is 최성준. 최성준 변호사님 would provide a recommendation for the improvement of invalidity process and scope confirmation process in Korea.
Yes. Good afternoon, everyone. As I was preparing for this conference, when the IP High Court was first established in 1998, the overall circumstances were not fully ready, and the work was still being done with not the full environment being ready. I used to work here back in the days, and afterwards I have seen that the IP High Court in Korea have made a lot of progress. And as Attorney Lee just mentioned, this has become a very successful case, which can be represented very proudly any part around the world. So talking about the improvement points about the existing revocation action is something that I was very cautious to bring up. But as a person who came in before you, I really would like to share my thoughts so that we can make an improvement together. And in the next session, we will be talking about the artificial intelligence. And when it comes to the inventive step of the patent, we cannot not talk about the artificial intelligence, so I will touch upon that aspect as well. And this is the agenda for the day. And among these items, number 4, which is related to the Trademark Act, I think I should just skip it. I was able to see that most of the discussions are focused on patents only, so I will be skipping number 4, which is trademark related item, and we'll cover 1, 2, 3, and 5. And when we talk about the revocation action, we cannot not talk about the inventiveness. And inventiveness is an item that cannot be very easily or clearly defined, but is a topic that should be covered. And when it comes to increasing the predictability of the inventiveness, this is very important. And when it comes to the general principle, there are 3 important ones. The one is the Foseta's technical level, and the other one is whether this is something that can be easily thought of based on the state of the art at the filing date, and the third one is that how easily it can be made from the prior art. And when it comes to the Foseta, this is playing a really important role in preventing the hindsight reconstruction. if you are considering the Foseta skill level too high, then it would be difficult to recognize. It would be difficult to recognize the inventiveness, and it would be easier to recognize the compliance with the specification requirement. But then when it is too low, it would be the opposite way. So it is very important to ask about what is the right level, appropriate level of the skill of the Foseta. And as I put it in here, the utility model review system in Korea does define the skill level of the Foseta, and what you should focus on in here is that in the later part of this description, it does talk about the person that is an imaginary one who can have the creative ability of doing the following things. And according to the Supreme Court decision, there is no clear description that is given by the Supreme Court. But when it comes to the patent decisions, patent court, I mean, they did add a few more comments to it. So it did include the point in time, which is at the point of the filing, and it also added that regardless of it being domestic or international. And when it goes down to the nitty-gritties, what is the skill level of the FOSITA? I mean, explaining the skill level of the FOSITA and defining the skill level of the FOSITA, how can we do this? It is still unclear, and this is the question that we have to deal with. So, according to the Supreme Court decision, the skill level of the FOSITA should be determined based on the records and the materials available. But if we are to do that, how can we actually acknowledge the skill level of the FOSITA using the existing recording and materials? I'm sorry, I'm on a wrong page, it seems. So this is a procedural law related item, and this is a requirement standard. So of course the adversarial system will apply, and the parties bear the responsibility, burden of proof, and the court, of course, will need to be making the establishment of the facts using the evidence and the arguments that were presented to the court. And the skill level of the FOSITA, I mean, there are cases in the Supreme Court where it was defined as a person who has the bachelor's degree in a certain art and has the 5 years of working experience in, for example, plating. But it is still not clearly defined, and there is still room for further discussions. And when determining the skill level of the FOSITA, so when determining the skill level of FOSITA, another factor should be considered, which is the technical field in question. So how will we define the technical field in question? Technical art in question is also another really important question. If we acknowledge it to be a very wide scope, then the level of the skill level required for the FOSITA will become too high. And there are some concerns about it. I'll touch upon this later. And recently, researchers are using AI, and that is affecting the skill level of the FOSITA. So that actually gives a little bit of an ambiguity in how we will define the skill level in the technical area. The skill level of the FOSITA and the artificial intelligence does have some relationship, so let me touch upon that topic. So the skill level of a FOSITA is basically based on the researcher's ability at this time. And they are now receiving assistance from the artificial intelligence. So when we are determining the skill level of the FOSITA, we should look at two different factors. The one is the knowledge, and the second is the creativity. And when it comes to the creativity, many researchers in modern times are receiving help from the artificial intelligence. Artificial intelligence does create art, but it's not even about that. When artificial intelligence is used to assist the creation of invention of a person, that would be considered the means, but then there are other cases where the artificial intelligence plays a even bigger role than just being the means. And there are many cases as such these days. So if the artificial intelligence plays a role in the creation in and of itself, then it will result in a higher level, higher maybe quality of creation or invention. Of course, when we are determining the skill level of a FOSITA, will need to think differently about the level of artificial intelligence usage. I mean, there will be areas where the artificial intelligence is widely used, and some other areas artificial intelligence is less used. So if we define it unilaterally across the board, it may also create complications. So the creative ability of the invention would be enhanced using the AI, and in that case, the existing inventive step standards is only based on the human researchers, and in that case, the patent would be granted more easily than it should. And this problem is dealt with in light of the current situation where the level of invention would be enhanced because of the use of AI, and we will need to adjust the bar accordingly. But some people argue that we will need to change the concept of the Fusita completely. Maybe we shouldn't just define it as an ordinary person. We will need to define the Fusita as Fusita using an AI or even an ordinary machine or AI, but I think it may be too immature to conceive that idea. And when it comes to the ease of invention, so when we are making a judgment, we are also looking at the ease of invention, and the specific judgment around that will need to be clearly written in the judgment, but that is not exactly done so well in practice. And the ease of invention is also closely related to the use of AI. And when it comes to the ease of invention, of course, the skill level of a Fusita is a really important issue, but then the AI, if it is used to help with the creativity, there could be a wider possibility of people making inventions more easily. So the standards or the requirement of inventive step can only get higher. And moving on to the hindsight aspect. I mean, we all understand that the hindsight reconstruction should be prevented. It is almost taken for granted, but of course, it is very difficult for a natural human being to think like they don't know something that they already know. So this is an area that is considered very tricky. And the Supreme Court also declares the principle that the hindsight reconstruction should be prevented, but then on how it can be prevented, it does not specify as to how it can be done. So I personally thought about ways to prevent hindsight reconstruction. And I thought about some examples, how they can be prevented. Not sure whether this is realistically possible, but when the person who is deciding on the inventiveness, that person I suggest should read the prior art documents first before reading the specification of the patented invention. In that case, the contamination in the thoughts could be minimized, and the prior art will need to be defined very reasonably in the analogous art. And when it comes to looking at the combination, how easy the combination is, we will need to look at how a Fusita, if there is a possibility that a Fusita would be able to make that combination, and whether the source of the technology is coming from the same or the adjacent art, or whether there is a reasonable ground for the combination. And moving on to the confirmation trial related to scope of rights. And for the international guests here, maybe you may not have good understanding of the system, but in Korea, we have had this system for a long time. And the appeals related to the patent infringement is being centralized, and there is a question as to how valid and how effective this trial system is. The Supreme Court does believe that it does, still serve the certain function, so it does acknowledge the validity of this, effectiveness of this, but then when it comes to the confirmation trial related to the scope of rights, it does have a lot of problems, as I would explain further later in the presentation. And recently, with regard to this confirmation trial of the scope of rights, we have seen multiple Supreme Court decisions. One is related to the 2014 decision. That was the infringement, but when it comes to that can be decided by the court. But then when it comes to the confirmation trial, it cannot be checked there. So it did made an effort to distinguish between the two. But in 2017 decision, it also allowed the free to use technology argument too. So this has been kind of undermined as well. And the Supreme Court en banc decision 2011, sorry, it also stipulated that when there is a conflict between the implementation of a later filed patent or utility model right and the earlier filed patent or utility model right, then the infringement is established. So there are some conflicting aspects to the decisions made by the Supreme Court with regard to the confirmation trials. So now I would like to suggest that it is time for us to maybe reduce the role of the confirmation trial and even think about whether this is really necessary, and maybe it is time for us to eliminate it. And third point that I would like to touch upon is related to the correction trials. I think the correction trials are excessively abused these days, and there are some cases where it reaches the Supreme Court and gets remanded. So recently we received a en banc decision. So when the revocation trial, a result comes out after the fact-finding procedures, then even if the correction trial is confirmed, that would not be considered as the changes to the administrative measures which served as the foundation of the decision. But still, there are many issues at hand, and we need to understand the intention of the Supreme Court clearly and find maybe the time frame window for the correction trials. And lastly, I would like to have a few personal comments. According to the civil procedure rule, the document length should be up to 30 pages. And of course, if there is an agreement with the court, it can be adjusted, but there is a rule that it should be limited to up to 30 pages. But then in practice, this is really not complied with. And as I am practicing as an attorney, if I want to put in everything that I want to put in, then it very often, goes beyond 30 pages. And as a counsel, of course, I will have to be very cautious about it. But there is one comment that I would like to give to the IP High Court. When the attorneys give you this lengthy submissions, think about why that is the case. I really hope that the tribunal, the panel, have good understanding of the earlier submissions. If that is the case, the attorneys will not have to rewrite. Once again, write the same thing that was already described in the earlier submissions. So please, there is one, I would say, comment that I would like to make to the judges, that you should be very well aware of what was already submitted to you beforehand. Thank you.
Thank you for a nice presentation. Next speaker is 한상욱 변호사님. I'll ask him to give overall evaluation of current IP system from the perspective of clients, especially foreign clients. Please give a presentation.
Thank you. My name is S.W. Han, the attorney for the Kim and Chang law firm in Korea. And today, for the sake of efficiency and given the limited time, allow me to present my materials in Korean. So for the foreign judges and attendees, please try to follow the screen. Sorry about that. 안녕하십니까. 한상욱 변호사입니다.
Yes, good afternoon. I'm Han Sang-woo. So within the limited time frame, I want to share with you my thoughts when I was first invited to this conference through our moderator, Kim. I believe this might be the last presentation for me, because we have excellent IP lawyers that are junior to me, and I believe I've attended all 10 conferences of this IP court conference for the last 10 years. So this 10th conference is very meaningful to me and to my junior lawyers. Always say IP is not one of them. It's not one of the laws, that it's a very special area, special roles. And what's been proven through this event is that in a court conference, we have, chief justices from high courts and Supreme Courts in attendance. I do not believe no other areas would bring out such a kind of the higher up. So I was very proud of this. So I do have many slides, and you can all forget about it, but please remember three things: international tribunal or the courts, and also a second, Korean hearing, and thirdly is the RCAP IP court. So these are the 3 points I would like to emphasize.
Today, my topic would be three ones. The first, Korean judicial panels. And then secondly, to prevent the hindsight, I'll talk about the Korean hearing. And thirdly, RCEP IP court, which is quite similar to the Asia IP court concept.
Now, UPC and ITC of the United States, how the inner workings of them, I do believe yesterday and also this morning, our honorable judges actually presented on them. So I'll just skip this part. But if you have time, you could maybe go over my slides. Then why, like UPC or ITC, or the Singapore court or Japanese court, why do we need to look at their practices? I really do not believe we are in competition with them, but at their courts, why are they have more cases than us? And is there anything that we could learn from or reference? Plus, of the ICT cases, there are also, of course, they also fought in the Korean court, but there were cases where if two Korean companies fought also in ITC. So for Korean court, maybe they went there because Korean court ruling was not sufficient enough. So in that case, we also need to take note of them. So as a practitioner to my international client, I always talk about the benefits or the good things of the Korean court system. So there are many, but it's about international judicial panel, which I'd like to explain more to you a bit later on. And then not only preliminary injunction dedicated division. which was established in 2016, do exist. And I believe to our international clients, it's impressive. So I actually two-tone about that. And also at the High Court, having the presentation practice at the first hearing, I do believe it's very efficient and effective. Of course, after even presentations, few more hearings are necessary, but it's very impressive. And also, there are provisions, the Unfair Competition Prevention and Trade Secret Protection Act. I think it's very much. I heard the Japanese side was very impressed about that. You know, document production orders and damage-related rules in that is dedicated on this area because injunctions sometimes are recognized, I believe, in the practice in Japan because it's based on the general damage calculation or anyways, punitive damages is also something we should also take of note. And also, I didn't put this in here, but the fact that we are looking at the timer, yes, timer also makes me heart throb every time, but I do believe it's actually a good practice. Then with KTC, now we do have Chief Judge of ITC here too, but we also have KTC in Korea, and I believe Korea is the only country, I mean, there are few that only exist in Korea in terms of IP regime. First is that we do have KTC, and second, at the customs, there is a system where they can prohibit related IP, and of course, court to then could that too. U.S., I believe, cannot do this in customs. And in other countries, they don't have KTCs or TCs besides Korea and the U.S. So I believe Korea is the only country that have these three systems. And KTC is improving very much day by day. So on the far left, for example, from China or from Japan, goods was made and bring it to Korea. So even if they were not produced in Korea or licensed in Korea, we still have the right to investigate. So it's kind of exemption to territoriality. And fourth box, within 6 months of the investigation, you have to make a decision, and if there's extension within 10 months, and it's very much strictly abide by. So by KTC, so it's something that we are doing well, and also special judicial police also I do believe garners a lot of interest. And so these are something that we should be proud of. And so if we are doing well in these areas, then we should also think about, is there any room for improvement? Because we can always make things better. But anyways, then what would be suggestion for improvement of Korean courts practice? So in that context, let me talk about the Internet Judicial Panel. So in 2018, our also the judge of the Supreme Court in the keynote presentation also said we also amended a court related act. Before that, court language was only in Korean, but with the International Judicial Panel to allow the pleadings in English, they actually amended the law. And I still remember the IP court chief judge and others even went to the National Assembly to explain their case. And after that amendment was passed, few gathered together to actually party about, celebrate it. But so I still have vivid memory of that. but it's being underutilized. And some people, even in the practice of IP, do not know its existence. So that's very regrettable. So there is a Supreme Court rules regulations of 2018 that's regarding the international judicial panel. We have a lot of Supreme Court judges joining us also in this court. So again, if you have the rules on this under Supreme Court, there is a lot of more things we can done. So maybe we could also think of that way. So not only maybe English, also allow other languages. And now both party needs to agree, but maybe one party applies and can be done through court decision, could be one way. And as an international judicial panel, Judge No talked about having in Sondo, and also the qualification of the attorney should also become more laxed. And Singapore, SICC, they even have foreign judges. And to do that, Singapore, I believe, as our Judge No said, even change their constitution. So I think we need to be more open in our thinking and flexible. The focus is about resolving the dispute. And in order to do that, what can you do more? To the applicant, if you can give more benefits, like as I said, KTC, you resolve cases within 6 months. So maybe benefit in discovery or faster decisions or judgment, that type of benefit, I propose could be taken into consideration. Now, case main conference was covered a lot in the morning. So I think in terms of adoption in Korea, I don't believe it will be very difficult, because there's a lot of also a court that makes us very much predictable in terms of case management. So I think there is a inducive ground to introduce them. So maybe setting all the schedules at the first hearing would be beneficial, as I've seen also done in Japan and other countries. And also Korean hearing. Now, if I go in this area, maybe some will say, oh, you are going into that again, because I always talk about this. But Professor George Mendel, I also saw him in person, actually had the three groups, foresight, hindsight, and debiasing group. And foresight group is only give technical scenario and don't tell how it was invented. So like baseball or fishing rod will be the things they need to create. Hindsight is they told the group how it was invented, and devising group is they told how it was invented and then said informed the problems of hindsight reconstruction. And the results are quite interesting. If you look at only on the obviousness area, this interesting is that the one that know the answer, hindsight, and the debiasing group, there's not much of difference between the two groups. But in foresight group, it was only 10%, so it was rather low. So I agree with Attorney what Che said. So in submitting the briefings to the court and also in doing hearings, you cannot talk of patent invention, and from the POSITA perspective at the time of application, like we go back to like 2001 and based on the literature at the time, explain it. Like why is it easy to have the patent invention? That type of hearing, I believe is necessary, and I've said that in many different occasions, and there have been a court that adopted this opinion too. But anyway, it's still very rare. And I think Markman hearing, everybody knows about this around the world. So maybe we can call this as a Korean hearing. That was my proposal. And at IP High Court, and also if you do have Asia IP Court, I do really hope that this can be adopted. And then looking at the IT technology level of Korea, this in I believe it's can be recreated at court. And if we have the international judicial panel, even with the video conference, you can recreate that. And I believe it's easy to have automatic translation service also. If I say something, have the translation on video. And so we can create a special court setting, like in Songdo, to promote the advancement of the IT technology of Korea to the world too. So again, IP's role is changing, and also ITC of US and KTC of Korea, like them, the administrative aspects can be introduced also in the IP court regime, and also various appealing process of the trade commissions could also be introduced to the court system. So what is RCEP? You might be wondering. It stands for Regional Comprehensive Economic Partnership. So in 2019, with 10 ASEAN countries, along with Korea, China, Japan, Australia, New Zealand, within these 15 members, they created IP agreement, and it assigns a higher level of obligations than TRIPS. So also when I posed questions yesterday from the floor, said EPC took more than 50 years in the making. So I do see that. But we don't even have any discussions about this establishment of the Asia's court. But that's not true. We do have ongoing discussion about this, and if not Korea, but other countries are also open to host at the location of RCEP IP court. So we have made some progress in this area already. And I really hope that our practices of Korea, because there's a lot of good things that Korea already does. So if that can be introduced and be helpful in the RCEP IP core, will be good. And maybe through that, Korea can take a leadership position in these efforts too. Thank you very much.
Thank you. Thank you especially for the introduction of Korean good practice and system. We can take pride. I would like to give several questions to the speakers on the presentation topic today, but we are pressed for time. I ask small questions only. 변호사님께 먼저 여쭙겠습니다.
I have a question to Mr. Kwon first. According to what you presented, when it comes to the right to claim injunction, you touched upon the need to consider the purpose of the Patent Act. The right to claim for permanent injunction may have to be limited in light of the patent scheme, the purpose of the patent scheme. But under our law, it does say that the patentee can file a permanent injunction claim against the infringer. And in a certain condition, you would like to make it limited, but then do you think that wording is enough to apply the permanent injunction in the way that you wanted, which is an unlimited scope? Or do you think we will need to create another provision that is allowing the judges to do so? As you are well aware, Patent Act and the patent right and the property right are two different rights. And as for the patent right, it does have a stronger public interest nature compared to the property right or the ownership right. So we can think about many different aspects based on your question. One aspect is related to the General Civil Act principle, and the other one is around the abuse of rights or the good faith principle being considered as part of the need for the permanent injunction. And we can also look at it solely from the Patent Act perspective and making a balance using only the Patent Act to make that right balance. And the fourth, probably the way to do it is to look at the case by case basis. And when the clear invalidity grounds are there for the patents, then they would, the Supreme Court would acknowledge the abuse of rights to make a decision. But that is something that I am not happy with, to be honest. So using the civil law principles to make a judgment in that aspect. I mean, this permanent injunction is actually stipulated in the Patent Act, not in the civil law. So the damages claim right is stipulated in the Civil Act, but the permanent injunction in light of the patent is actually not just a civil act. It's different from the property claim right in the Civil Act, civil law. So ultimately, we will need to revise the Patent Act to be able to allow for more discretion of the judges. So I would say that I think it is necessary for us to maybe add a new provision with regard to that. But when it comes to reality, it will take time to make such revision. And as for the non-compete clause, I mean, it doesn't have the specific duration, but based on the precedents, I mean, it does specify it as a 1 year in many cases. So it's not just like that. Maybe we can do the same here. Even until the revision is in place, we may be able to allow for a certain time frame or certain scope based on the discretion.
금지 청구권을 일정
Thank you. So making some limits to the permanent injunction, on this view, what are your views? I would like to hear from the three other attorneys in order, please. Starting with Mr. Lee. As for the preliminary injunction, it is related to the preservation need, and it's also related to the public interest, and the dismissal can be done based on that consideration. But when it comes to the right to the permanent injunction, if the violation or the infringement is objectively acknowledged, then it would be considered as a right that can be claimed. So based on the current status, it would be difficult to apply the discretion. And that can actually weaken the protection of the rights, and it could also undermine the legal certainty as well. I mean, the pharmaceutical medicine, drug making, or the, invalidity of a patent could be the exceptions. But if you are applying the balancing act across the board, it may be a problematic too. Yes, thank you. And the next one, please. I agree with what Mr. Lee Sang-ho just said, but I can see Mr. Kwon Taek-soo's point. I mean, this is a very meaningful point. He touched upon a really meaningful point. This is worth reviewing, but there is a prerequisite, though. The prerequisite is that, as Mr. Lee presented, the damages system will need to be first clearly established. So if you pursue a damages claim, then you will receive a bigger compensation or the equivalent amount of compensation, and your rights will be protected. If that can be guaranteed, then we will be able to put in some balancing act related to the permanent injunction claims. But at the moment, it is not the case, so maybe it will be too harsh on the rights holder, which would be the patentee here. I see. So we will need to consider it even more holistically, including the damages system. And moving on to Mr. Han. Well, without the revision of the Patent Act, applying this discretion would be quite difficult, I think. And we heard from the US about the eBay case. I mean, there was a revision discussion related to it, and the ITC, as you know, when the infringement is acknowledged and the exclusion order is acknowledged. So in practice, as of now, we don't want to see that the protection of the patent holder being even more weakened. Thank you so much for your input. So the injunction and the damages are two big pillars, so we will need to have a good balance between the two pillars to be able to have a stable legal system. Then let me move on to the damages because we are on that topic. When it comes to the damages system, many people believe that the Korean damages system is not sufficient. I think many people say that. I think that, so if that is the case, if the damages system in Korea is not sufficient, what do you think is the root cause behind it? What would be the biggest reason behind the insufficient damages system in Korea? And let me ask this question to Mr. Lee first.
Well, as I said in my presentation also, now for more effective damage compensation, the interest of the infringer and patentee needs to be estimated based on factual evidence, but we do not have discovery systems, and even the evidence that production orders are complied with, so we cannot give more accurate calculation. So it's based on the court discretion, thereby resulting in ambiguity in terms of the number calculation. So in terms document or in the evidence collection and production, court needs to become more tighter in terms of supervision and needs to hence becoming more effective. Okay, so in terms of invented step issue, now what is invented step and what's non-inventive step of the invention? So I think the key is which criteria you use. What is the standard? So you said there should be clear standards involved. And one of the things that we could consider
would be that which is something that is not really considered so much by the Korean court, which is called the second consideration. At the moment, the Korean court actually considers it only as a supplementary opinion, but then maybe there is a need to consider it more closely. Maybe having it as a main consideration. What do you think would be a better option, Mr. Che? Well, this is related also to the hindsight reconstruction. And the secondary consideration is, of course, secondary, so it cannot be primary. But in the Korean law practice, the secondary consideration part is considered very lowly. It is something that is not considered very importantly, so we will need to consider that aspect. And in practice, I mean, I did this when I was practicing in the past. But when we are thinking about the infringement and the inventiveness, I first consider the construction, and if there's no much of a difference there, then the effect is not really very much explained. But so if the difference in the construction, I mean, can that be overcome by the inventiveness? I mean, that is not really connected closely with the effect in the explanation. So maybe this will not just have to be the secondary consideration. If that is related closely to the effect, then it will need to be considered as a more important aspect. Thank you. The representative consideration would be the sales, and this is definitely an objective information, so that will need to be considered by the court. That was your opinion. And moving on to Mr. Kwan, I mean, what do you think is your view? What is your view on the secondary consideration? Well, inventive step is something that is most tricky when we are considering the validity of a patent, and I am not always very confident about this. I mean, I felt that as a judge, and I am also feeling that as an attorney at the moment. I mean, whether this is inventive or not, there can be different views depending on where you look at it from. So it's a very tricky part. And the secondary consideration, I believe, is considered as like 5 to 6 different indicators in the U.S. I mean, this is a consideration that is widely used in the U.S. I mean, licensing, experts, pessimistic view, and the imitation of a competitor. Those could be the major factors that are considered in the U.S. But in my view, the most important thing that should be considered when we are talking about the inventive step is the task or the challenge that was not tackled for a long time. And this is actually a very important aspect in the technical development, and whether this is a invention that is hard to achieve by the Fosita is also seen through this indicator, and this is something that can be easily proven too. The commercial success is something that we easily take or accept, but the commercial success can actually easily also segue into an hindsight consideration too, so we should be very careful. Thank you. Thank you so much for your opinion. Moving on to the confirmation trial and the infringement proceedings, them being overlapping. Mr. Che gave us that sort of opinion when he delivered his presentation. And about this, the confirmation trial, based on what we learned in the past, I mean, this is a type of proceeding that is existing only in Korea and Austria. So the confirmation trial for the scope of rights, I mean, should it be maintained? I think there are a lot of discussions about this and many question marks about this. And can I ask the other attorneys to give an opinion? Well, we heard from the Supreme Court, but in practice, many practitioners think that it is still, valid. And when it comes to the passive confirmation trial, I mean, there were some cases where I saw the parties settling thanks to that, so there could be some validity to it. But then, from a more detailed point of view, there could be some problematic aspect to this system. Despite that, I mean, this is a confirmation, and this is also related to administrative aspect as well, not just judicial one. So maybe having a confirmation only that may stay, that may be able to be maintained without any problems. I will think about this even more deeply afterwards. So, Mr. Lee, could you share your thoughts on whether this would be, and if this is an effective system, and what's your view on this? Well, this is a system only existing in Korea, and should it really go into a trial, maybe eliminating it completely or reducing its scope is something that I hope to see in the future. But when it comes to the passive confirmation trials, and even the ones that will be held in the future, I mean, this is still allowed, and I have a lot of questions about this because I mean, this actually system is in place because of the legal certainty. But then, if we have a right to claim for the confirmation trial, even for the items that will be, put in place afterwards in the future, then it is actually going beyond what it is designed for. So I will be implementing this claim in the future. That is the argument that the patentee makes when they're making that claim. But if that is allowed, who would be completely ready when they are making the argument, right? So from the respondent's point of view, I mean, they would be going into this dispute regardless of whether they want to do it or not, and regardless of whether they did something wrong or not, and be wasting a lot of time and money. So When it comes to the confirmation trial, I mean, that would be specifying the target opponent. But then when you are actually implementing it in another, invention, so in the confirmation trial, you use item A, but then in the actual implementation, you use an item B, then there is a contradiction between the two, and that will give rise to another litigation in the future, which is related to the actual rights. So this may be resulting in unnecessary disputes even. Thank you so much for your view. Moving on to the last topic.
So to Mr. Han's presentation, the International Judicial Panel need to look at more cases. So specific way would be allow other language besides English, and in proceedings, without getting consent from the opposing party, you could still pursue with the International Judiciary Panel's proceedings. So the applicant pleads in foreign language, and if they submit the briefs in foreign language, that the applicants, might find it easy, but the opposing party, like a Korean party, although they did not agree on this, they have to do everything in English, although they're doing this in Korea. So if it's an international case, yes, it could have bring more foreign clients to Korean court, but Korean company that has to go through these proceedings as an opponent, what kind of benefit can they enjoy? Now, in terms of translation, if you look at Article 4 related to the operation of the International Judicial Panel, they say they can establish interpretation service center. So we have done few cases already, and the simultaneous interpretation service was availed through the court. I believe a translation service, written translation service can also be availed through the court. So I only do not plead, plaintiff case, but also defendant case. But there is no proceeding that satisfies all parties. If it's quickly done, maybe only it's really satisfactory only one party. So when I was in the U.S. court, what was impressive was that judges say, quote unquote, my court. So in my court, they say I'm the king. So this is Korean court, and they have to abide by the Korean rules. And if you state then it will go. So if everything there cannot be where you satisfy every body. So if there is a bigger kind of value involved, maybe sacrificing few minor interests would be acceptable. Well, I do have more questions. I'm even open the floor to the question, but due to time constraint and as a moderator, I'm obliged to serve my role as timekeeper. So I'll end this session here, and please thank our panelists' efforts with one round of applause. Thank you so much, and thank you the panelists and the moderator for this session for their input and efforts. We'll now get a short break and resume with the last session of the day from 3:30.
Session 5 will begin shortly. We kindly request the participants for session 5. We kindly ask everyone to take their seats. 안내 말씀드립니다. 곧 5세션을 진행하겠습니다.
Now start with the afternoon session, last session of the day. I'd like to ask everyone to take your seats. Thank you.
오 세션 곧 시작하겠습니다. 모두 자리에 착석해 주시면
We will
감사하겠습니다.
begin
We kindly ask
the
everyone
fifth
to take
session
your
shortly.
seats. 감사합니다. 이제 오늘의 마지막이자
Thank
이번
you.
컨퍼런스의 마지막 세션인
Now we
오세션을
will begin
시작하도록
the fifth
하겠습니다.
session, which is the last session of the conference. In the fifth session, we will be covering the topic of artificial intelligence. And this session will be moderated by Mr. Lee Kyu-hong, Chief Researcher from the Judicial Policy Research Institute of Korea.
큰 박수
Please give
부탁드립니다.
them a big round of applause.
예, 방금 소개받은
Yes, as introduced, I am Lee Hong from the Judicial Policy Research Institute of Korea. And let me introduce to you what this institute is about. Well, in Korean, I feel bittersweet about this conference because we have been having in-depth discussions from yesterday till today, and we have had heated discussions and we have seen delays because of the heated discussions. I'm very happy to be part of this. And JPRI, the institute that I am coming from, is like the US is unlike the FJC. I mean, the FJC is doing both the training and the research, but then the JPIR is the research-focused research center that is under the Supreme Court. And this research center is focused on research, and the training is done at the a separate training center. We have around 10 doctor's degree researchers, and we also have 10 double-heading judges in place so that they can make the blueprint for the future for the judiciary system in Korea in the mid to long term. And one book of the roadmap is up to like 200, 300 pages, and we have published multiple multiple books so far. And I've worked at the Korea IP High Court for 6 years, since 2013, and I have always attended the conference. And in 2020, in 2021, even though there was COVID, we have been holding this conference every year despite all the difficulties. And Judge Kent Jordan, yesterday said that he joined this conference via Zoom remotely, and Judge Richard Mead also joined this conference via Zoom around, I think, 2021. But then due to the time difference, you must have had a lot of difficulties. And I once again want to thank all the participants who came to this conference before, even via Zoom. So those two personal notes were something that I wanted to say before we jump into the session 5. So we have 4 distinguished panelists for this session.
우선 소개를 시켜드려야 되겠습니다.
Let me introduce them to you. First of all, we have Judge Jorn Pedersen from Federal Court of Justice in Germany. And you have met him in the earlier session today, but once again, please welcome him with a big round of applause. And we have District Judge Kiyo Matsumoto from the United States District Court for the Eastern District of New York. You have met her in the morning session, and she must have left you with a big impression. Please welcome her with a big round of applause. And we have 2 judges from Korea, and they are in charge of 1 part each. First of all, we have a presiding judge, Son Young-won, from the Daegu District Court of Korea, who will be dealing with the IP part. I was part of the same panel with him, and the Paris Paris University LLM is the degree that he has, and we also have Kwon Bo-won, the judge from the IP High Court of Korea. As you can see from the profile, he has studied multiple fields, and he also received LLM from the US's George Washington University. So today's topic is artificial intelligence. AI is a buzzword in all the conferences that are held recently, this is such an important topic. And the development is happening at a rapid pace, and we cannot even imagine what will happen in a week's time. And that is why that if there are legal discussions involved in it, not a lot of discussions are at a mature level yet. Only a few cases held in the US and not many in the world. So we would like to talk about this topic very specifically. So in the earlier sessions, I mean, we had a lot of practical discussions, but in this session, we won't be able to have a lot of practical discussions because this is so recent. And the reason why this is in the last part of the conference is because of that aspect. I mean, we would like to look at the topic from a future standpoint. That is why this is at the last part of the conference. But as said, in the large law firms, this IE's use could lead to a leakage of information to the outside, so they are worried about it. And in the smaller, law firms, junior, attorneys are using this very aggressively based on what I heard. And in the Judicial Training Conference, what we say is how we can prevent abusing the AI to the junior law practitioners, legal practitioners. But based on what I heard, well, the world is changing rapidly, and a big driving force behind it is the social media. Social media is spreading fake news, and that is polarizing people. The middle ground is, evaporating, and that is based on algorithms. And the initial regulation on the social media failed. That is also a view held by some people. And on the artificial intelligence, it is exactly at the point where it is now, at a nascent stage. And if regulation is a too big a word, then maybe this is the time for us to start having a really in-depth thought about it so that we can be prepared. So today we will be discussing two different parts. The part one is about AI and related IP rights issues, and in part two we'll be talking about the use of AI in legal proceedings. And if you look at the booklet, it starts from page 416 in the English version, and in Korean it starts from page 512. So if you would like to refer to the materials in the booklet, those are the pages that you will have to remember. 416 for English, 512 for Korean. And we have thought about many different options of running the session, and as I explained earlier, this is not exactly an area that is clearly shown in the actual legal practice, and there's a lot of blanks in this space, and we need a lot of imagination to be able to be prepared for the future. So that is why we divided it into part one and part two, and I will explain to you about what the overall questions are in those two parts, and then we will be asking the questions to the judges in front in order. And at the end of the session, we will open up the floor so that we can take questions also from the audience as well. And Attorney Choi from the earlier special session made a good point about artificial intelligence, and let me summarize it for you. When it comes to determining the inventive step, according to Mr. Choi, artificial intelligence use may make it ambiguous what the scope of VOSITA should be. We will need to consider that aspect. And well, it is maybe not, maybe it's too immature for us to move on from VOSITA to MOSITA. So we are, I think, at a early part of the transitional period. So I think the session is even more meaningful because we are at that timing. And well, I've been a bit lengthy in the introduction, but that is the context that I wanted to set for you. The questions are in the pages, And let me briefly explain the questions for you. Let me ask the first question, which is related to the IP cases. And these are patent, trademark, and design related IP cases. When it comes to those cases, there could be issues related to AI, and we hope the judges to introduce to us about these IP cases related to AI. And the second question is on page 475.2. When it comes to the, for example, copyright, what is going on. Fair use provision is there, and if there is any, cases related to the fair use provision is something that we also gave the question about. And when it comes to the AI, the copyright becomes an issue. So what would be the ways to address the issue related to copyright? And when it comes to TDM, text data mining, is there a provision that is giving the waive to the TDM regulations? And if the royalties are paid, should we look at it from a conventional point of view, or should we look at it from an alternative point of view? So these questions are really based on the imaginative future scenarios. And we wanted to have a discussion in advance before they unfold in full swing. And the last question is around the AI-generated content and the outcome that comes out from the usage of AI. And we wanted the judges to share some of the cases related to that. So whether there are any relevant cases and the disclaimer, I think those could be an important aspects to the last question. So with regard to these questions, I would like to ask Judge Featherson, to give us the answer as a starter.
Thank you very much, Presiding Judge Lee, for your very kind and thoughtful introduction. In fact, this panel poses a challenge to me in two respects. One, I don't really have a grasp, and this seems to be a recurring topic for me, of the technical background of AI at this point. But I'm very much looking forward to the contributions by Judge Sohn and Judge Kwon, because I know after that, there won't be a question open. So. And the second challenge actually is that we don't have German or even European case law right now. So we are very thrilled and looking towards the United States, and I'm relieved that my neighbor Judge Matsumoto will provide you with quite some case law that has evolved in the United States. So thank you very much for that. We have been granted some leeway in how we structure our remarks today. Thank you for that. And I have put down what I would call a couple of speculations in my paper that you may or may not take in at some point, but these are speculations. Because the questions as to AI and patent, design, copyright, and trademark law are widely open, and answers will have to be found on a step-by-step basis, I assume, case-by-case basis. And it's such a wide field, such a wide range of topics that I decided to restrict my remarks to something tangible, right, that I can present to you as something that is already reality, at least as far as regulation goes. So I would restrict my remarks at this point and like to familiarize you with the EU regulation on artificial intelligence and its ramifications as it comes to copyright issues. But please feel free to, if you have questions afterwards concerning the first pages of my contribution in the booklet, feel free to ask those questions. Now, ladies and gentlemen, we all resent bureaucracy, right? However, at least in the European Union, we love to treat ourselves to a nice and juicy regulation. And this is quite much the case as it comes to the brand new EU regulation about artificial intelligence. And before I lay out the legislative frame, I would like to say a few words about the European Union copyright law regime so that we can put it into perspective, because the AI regulation is, I would say, not at all a copyright regulation. It is rather the case that, as I have heard, during the very end of the legislative process, which is to some extent obscure on the EU level, I must say, to the very end of it, some copyright wording went into the regulation, but it is not really the core of it. So let me please, clear up a few things as far as European copyright law is concerned. This is an area of law that is quite largely harmonized by European directives, first and foremost by the Directive 2001-29, and from now on I will refer to this directive as the InfoSoc Directive, as its full name is Directive on the Harmonization of Certain Aspects of Copyright and Related Rights in the Information Society. InfoSoc Directive. Certain aspects, you may wonder, certain aspects, what does that mean? Well, in the jurisdiction of the European Court of Justice, it means actually, evolving and, an area of harmonization that is getting more and more, in size and range under the hands of the European Court of Justice. So it started with certain aspects, but we are quite far now in the harmonization as to, the idea of work, protected work, for example, which is the central notion of copyright law, obviously. According to Article 3 to 4 InfoSoc directives, member states shall provide for the authors exclusive rights of reproduction, communication to the public, and distribution. So these are the core rights of the author. And under the structure of the directive, in Article 5, certain uses are exempted from the author's exclusive rights. So you may notice we don't have a broad general fair use clause as we know it from the United States. Rather, we have quite an impressive set of a couple of exclusions, exemptions from copyright that are very specific and have a very narrow range. And I would like to mention a few of those. For example, temporary acts of reproduction that are transient and incidental and an integral and essential part of a technological process are exempted from copyright. Also, reproductions on any medium made by a natural person for private use, neither directly nor indirectly commercial. So the private use exemption. And also this exemption requires that that the right holders receive fair compensation for this private use exemption, which obviously in Europe is dealt with by the collection societies, the copyright collectives that administer the royalties that are being paid. Maybe we will come back to that point later, because the question obviously on the table is, what about royalties for the use of protected work that goes into AI? Then we have an exemption for quotation, criticism or review, for the incidental inclusion of a work, for the use for the purpose of caricature, parody, or pastiche, and I'm desperately waiting for AI learning humor. That must be marvelous. I'm looking forward to it. And then all these exemptions only apply under the condition that the exempt uses do not conflict with the normal exploitation of the work or other subject matter, and do not unreasonably prejudice the legitimate interests of the right holder. So this is the frame set by European Union copyright law. And now I will go on and tell you a little bit about the Directive 2000. Oh no, sorry, I have to add one more exemption, which is very important in that context that we are talking about, and that is the exemption for the purposes of text and data mining. And this exemption has been added to the catalogue of exemptions by the Digital Single Market Directive that was adopted in the year 2019, and it exempts for the purpose of text and data mining, and says reproductions and extractions may be retained for as long as is necessary for these purposes, and the exception or limitation shall apply on condition that the use of works and other subject matter referred to has not been expressly reserved by the right holders in an appropriate manner, such as machine-readable means in the case of content made publicly available online. So this is an important condition. As a right holder, you can express a reservation if you are able to put that in your code, of the website or whatever you are actually publishing. And also, the exemption includes reproductions and extractions made by research organizations and cultural heritage institutions in order to carry out, for the purpose of scientific research, text and data mining of works, and so on. So this is the headline, the headline text and data mining exclusion. And that is quite of some importance if we talk about how we actually get artificial intelligence going. Now actually I'm coming to the regulation 224/1689, the AI Act. And I must tell you, I have already mentioned, it's not a copyright act in itself. So what is it? It basically has a product safety approach, if you will. Because, and I would like to cite recital 1, its purpose is to improve the functioning of the internal market by laying down a uniform legal framework, in particular for the development, the placing on the market, the putting into service, and the use of artificial intelligence systems in the Union in accordance with Union values, to promote the uptake of human-centric and trustworthy artificial intelligence, while ensuring a high level of protection of health, safety, and fundamental rights. This AI Act is effective as of August 2024. Overall applicability starts in August 2026, so we have 2 more years to get ourselves acquainted with this subject matter. Although the rules for general purpose AI models, and those are the ones that we are talking about in the copyright context, are applicable as of August next year. Now, I will tell you what the content of the AI Act actually is. Now, first of all, the regulation prohibits certain AI practices. And I will just tell you a few. For example, subliminal techniques beyond a person's consciousness, or purposefully manipulative or deceptive techniques, with the effect of impairing the person's ability to make an informed decision. You know, the idea of the informed decision is a central notion of European Union consumer protection law, and that has also found its way into the AI Act. Secondly, what is prohibited? Exploitation of the vulnerabilities of a natural person or a specific group of persons due to age, disability, specific social or economic situation, also not allowed. Also prohibited risk assessments of natural persons in order to assess or predict the risk of a natural person committing a criminal offense, based solely on the profiling of a natural person. Also prohibited creation or expansion of facial recognition databases to the untargeted scraping of facial images from the internet or CCTV footage. So this is, I would say, the catalog of the most important prohibitions that the Act actually provides. And now I will go on and tell you about the other regulation goals of this Act. One goal is to regulate AI systems, so-called AI systems with high risk. And the AI Act understands as AI systems with high risk, biometrics, critical infrastructure, education, employment, essential services, migration, administration of justice, and democratic processes. So another, if you will, restriction. Then it holds transparency requirements for certain other AI systems. For example, if I call a hotline and on the other end of the line there isn't a natural person but rather an AI-run computer system, then I will have to be informed about that fact, that I'm not talking to a human being. The AI Act creates a new authority, the AI Office, established as an agent of the Commission, that administers the regulation, has exclusive powers to supervise and enforce. So there's no private enforcement of the AI Act, at least at this point. This is a piece of administrative law, if you will. And the AI Office can set fines for infringement in the case of failures to comply with the request of the AI Office, and this can be up to 3% of the total worldwide turnover, or 50 million euros. Now we are talking, ladies and gentlemen. Okay, now what are the copyright-related provisions? I would like to start to tell you that they only apply to general purpose AI models, which are defined as including an AI model, including where such an AI model is trained with a large amount of data using self-supervision at scale, that displays significant generality and is capable of competently performing a wide range of distinct tasks regardless of the way the model is placed on the market, and that can be integrated into a variety of downstream systems or applications, except AI models that are used for research, development, or prototyping activities before they are placed on the market. So the eye of the regulation basically is, on AI that is placed on the European market. Providers of general purpose AI models shall put in place a policy to comply with union law on copyright. However, the AI Act does not regulate what that actually means. So it is up to the providers to come up with some, informal regulation among each other to make sure that this requirement is is kept. With this, I would like to turn to a provisional appraisal of the copyright-related effects. And I will do that. I will state that this is my personal view and not at all binding upon my esteemed colleagues at home. And I would like to start with the idea that the reproduction of copyright-protected material for AI training, so the very first part of the whole adventure, is probably exempted by the data mining exclusion. This wasn't so clear before the Digital Single Market Act. We were all wondering how we actually would look at AI and the use of protected data. But since in the Digital Single Market Act, as I cited before, these data mining exemptions are regulated, and also the AI Act refers to the data mining exclusion as a possible tool, we can probably say that this exemption is applicable at this point. Now, you have to prompt something to the AI so that you get a result. You might use copyright-protected material while prompting, and I would guess that this probably is a transient reproduction, so another exclusion would apply. And then we come to the more sensitive issue of reproduction of copyright-protected material and the output of AI. And this is probably where we will start at some point with our case work. Because, as I told you, if a user doesn't have the right of use, the reproduction is only allowed if an exemption applies. And so this is probably not temporary, because this is a permanent result that we want to, put on our wall or do whatever with it. The exemption for text and data mining probably only applies for the training phase. It is also not an incidental inclusion. It is practically the whole point, probably, of the result that you probably recognize the protected work. As AI doesn't quote as of today, quote meaning also making visible your source, the exemption for quotations probably wouldn't apply. Maybe the exemption for the purpose of caricature, parody, or pastiche might apply if you have this kind of material coming out of the AI. And then you have the exemption for private use, and that probably is applicable. And the question arises: shouldn't the copyright holder be remunerated for, their work that has gone into and come out of the machine? This is an open question because the AI Act doesn't confront this issue, and the EU legislator has not, as of today, regulated this point, not even as an option for the member countries. But I think this is something that we will increasingly talk about in Europe, at least. Now, what are the obligations of AI operators? As I said, the Act requires that the operators put in place a policy to comply with union law, that poses quite a couple of questions that I have put down in my written presentation. For example, issues of territoriality, quite thrilling questions. Only to reproduction in the EU, or doesn't it matter whether reproduction happened? I mean, that would be the conventional copyright attitude, right? That you look at the location of the reproduction as, because of the territoriality of the copyright, other reproduction wouldn't be relevant at that point. But it is quite open whether it is sufficient that the AI is placed on the European market, even if the reproduction has occurred somewhere else. Then in the training phase, the operator has to provide a sufficiently detailed summary about the content used for training. This would allow at least to have some, some hint as to what kind of material has gone into the machine. It's probably not realistic to expect that there would be, my work being cited in this overview, but maybe the database would be identified that has been put into the machine. And then again, in the implementation phase, the operators have the obligation to put in place a policy to comply with union law. This act probably envisages a model of that we know from other fields of IP law, a system of notice and takedown, if that is appropriate. Looking at the time, I will stop at this point, and I'm looking very much forward to the following presentations. Thank you very much.
대단히 감사합니다. 상세한
Thank you for a detailed presentation. The copyright issue, we do have the IP High Court in Korea that is dealing with the copyright. I mean, we hope to be able to cover those areas together with the IP issues, but then this was kind of being not covered so much by the High Court. But then we do have a lot of copyright-related directives in place. And you touched upon, and it also regulates some of the common use or general use AI as well, and it seems very complex. And thank you so much for the detailed explanation, and it requires further study, I believe. And next, I would like to ask Judge Kiyo Matsumoto to give us the explanation on the U.S. situation.
Well, unlike the EU, the United States has yet to pass any legislation guiding our society as to the proper uses of AI. So courts are on the front line of trying to interpret and make sense of this very rapidly emerging technology. And we often look to principles of patent, trademark, and copyright law and the surrounding cases. So in my materials, or in the materials that you have, I've got certain cases that have been summarized for you. One of the main cases, Thaler versus Vidal, stands for the principle that a natural person, and only a natural person, may be a patent holder. A fellow named Stephen Thaler attempted to have his AI system DABUS, which stands for Device for the Autonomous Bootstrapping of Unified Sentience, recognized as an inventor. And the U.S. Patent and Trademark Office rejected this request and found that only a natural person could be designated as an inventor. The Federal Circuit upheld that decision, and the United States Supreme Court denied certiorari. So that is still the case. Moving from patents into copyright, similarly in Naruto versus Slater, the court similarly held that only humans can be recognized as authors under copyright law. And this does impact AI-generated content because it establishes a non-human creator and the principle that a non-human creator cannot fully own a copyright. And finally, in Perry versus Shine Distribution Corporation, a lawsuit was brought by a number of designers against the defendant, which was an online fashion retailer that used an algorithm to scrape the internet for fashion designs, often using existing designers' work and creating fashions based on an algorithm. So this is still in discovery. The case has been challenged in a motion to dismiss, and it's awaiting a decision. Did you want me to talk about generative AI too, Judge Lee, at this time? Okay. All right. So ChatGPT was created by OpenAI in late 2022, and a lot of litigation has arisen from that system. Generative AI produces outputs based on learning. AI is capable of learning from vast amounts of data, and concerns have been raised about copyright infringement during the AI learning and training process. So there have been lawsuits surrounding that issue. First, when we talk about AI training data and the collection of information that these AI outputs are trained to utilize, the courts have grappled with how to deal with these challenges. The cases generally fall into different categories. First of all, copyrights and IP issues, data privacy, and security questions. Regarding pictures or images, Getty Images versus Stability AI was a lawsuit by Getty Images which sued Stability AI, which had trained its generative image models to search millions of copyrighted images from Getty's catalog without permission. And the case has continued on. It is still active. Getty Image requested oral argument on Stability AI's motion to dismiss and transfer the case to the Northern District of California from Delaware, and that case is still pending. I believe oral argument did take place. Also, we look to literary works, the written word. Authors Guild versus OpenAI was a class action by different authors against OpenAI, which accused AI of using copyrighted literary works to train its AI models, including ChatGPT. The plaintiff argued that the ability to summarize and generate text and mimic the literary works of copyrighted material was an infringement. The case is still in discovery. A recent case filed by the New York Times against Microsoft and other AI vehicles like ChatGPT alleged that OpenAI used New York Times actual articles to train its model to answer prompts generally, and that in that process of training, what was generated were either exact or nearly exact copies of articles to which the New York Times held copyrights. Another case concerned music, copyrighted song lyrics versus Anthropic. This is a music group that had the rights to different song lyrics and challenged an AI developer, Anthropic's models, which would pull, again, copyrighted music without obtaining permission. The music publishers allege that Anthropic improperly used their copyrighted song lyrics to train its generative AI conversation interface models. This was a device or an entity called Claude. It was a large language model training with vast amounts of text that it copied from the internet, totaling billions and trillions of words. And Claude claimed that it didn't merely regurgitate, but actually applied complex reasoning, creativity to its training corpus in a way that approximated to human cognition. The plaintiffs disagree, of course, and allege that Claude would get prompts and pull the lyrics, these millions of lyrics, and produce, again, identical or nearly identical copies of those lyrics. The case is in discovery, and it has recently been transferred from Middle Tennessee to the Northern District of California. The appendix in your materials does summarize some of those cases. Did you want me to discuss fair use now or later, sir? Judge? Judge Lee, did you want me to discuss fair use?
예, 공정 사용과
Yes, please, including TDM. Also, if you could cover that also, thank you.
All right, as we know, fair use under the Copyright Act of 1976 requires courts to consider 4 factors. First, the purpose and character of and use of the work, whether it's commercial or for nonprofit or educational purposes. This somewhat mirrors the EU concern about commercial use versus personal use. Second, the court considers the nature of the copyrighted work. Third, the amount and substantiality of the portions used in relation to the copyrighted work. And fourth, the effect of the use on the potential market. So courts look at factors 1 and 4 as probably assigning the most weight. Factor 1, the purpose and character of the use, was almost entirely a question of how transformative the work was. In Campbell versus Acuff Rose Music, a 1994 case, the Supreme Court set aside this concern about commercial use not being a fair use, but rather looked at whether the work had been transformed and found that parody was a fair use. In that case, I don't know how many of you know the song, Roy Orbison's song, Pretty Woman. A rap group called Two Live Crew did a parody of that song using the same tune, but changing somewhat the lyrics. And the court found that there was something new that had been added to that song with a further purpose of parody. And the more that the transformation occurred, the less the court would be likely to find that the other factors were of significance. Factor 1 was also used in the Supreme Court's consideration of Andy Warhol Foundation versus Goldsmith. And there, the court advised the lower courts to think about not just how much the defendant has transformed the work, but how the challenge use differs in purpose from the copyrighted use's purpose. There, Andy Warhol Foundation had sold a silkscreen, a photo of Prince, the musician, that was on the cover of a magazine, and held that that was not fair use because the photos that the original photographer took of Prince had the same purpose as the Warhol use of the same image. And when one has a risk of substituting the allegedly infringing work for the original work, then the court is going to look for relevant and independent justifications. Is there parody? Is there criticism? There, the court made somewhat of a departure from the prior Factor 1 analysis. Factor 4 is the effect of the challenge use upon the potential market for the copyrighted work. So there, we look to whether the copyrighted work itself is a derivative, is for a derivative market. An example is if an author writes a book, and then that book, without permission, is made into a movie without the author's consent, what it does is it impedes the original copyrights holder's ability to derive benefit from his or her own work. So the court will look to the impact on the market and would consider whether or not the authors continued writing new books if everyone knew that a writing could be used for a movie or some other purpose. Courts also look to public benefit. There, in Google versus Oracle, Oracle sued Google for taking whole cloth some of its declaring code and incorporating it into the API or application programming interface for its Android phones. An API allows computer programmers to use pre-written code to build certain functions into their programs without having to rewrite or create their own code from scratch every time they want to perform those functions. The Supreme Court held that this had to be considered fair use or the public's interest would be harmed because enforcing Oracle's copyright in this instance would lock or preclude or limit future creativity of new programs. And certainly in terms of generative AI, this issue may arise again. Factor 2 concerns the nature of the copyrighted work. This is typically not the deciding issue, but courts are more likely to protect works of fiction or creative works rather than a news article, a speech, or some existing more fact-based work. In Hatchet Book Group versus Internet Archive, the Second Circuit Court of Appeals explained that Factor 2 involves looking at as if the copyright work is expressive or creative. They are closer to the core of the intended copyright protection, which is to protect creative works versus more factual works. Factor 3 is the amount of and substantiality of the portion used, and this is whether the defendant used more of a work than is needed to achieve its purpose. So in Harper Row Publishers versus Nation Enterprises, the court found that Factor 3 weighed against fair use, where a magazine article copied the most important passages from Gerald Ford's unpublished memoir before publication, rather than summarizing it or just quoting small portions. And so there, the court looks at how much of the protected work is being used to find whether or not Factor 3 should control. Again, I refer you to Appendix 3 for a summary. Did you want me to move to training data?
예, 디테일
Yes, I think that's about will do. So whether the copy rights can be protected on the derived work.
AI generated content. 질문 3번, 질문 넘버 3.
Federal courts are currently weighing whether generative AI models infringe copyrights or alternatively whether AI models' use of copyrighted training data constitutes fair use. There are 3 categories of such cases. First, cases regarding feeding books and articles into large language models, also known as LLMs like ChatGPT. Second, cases regarding feeding visual art and photography into generative AI models, like Stability AI. And third, there's the only case that we found as of a few days ago that has provided guidance in evaluating fair use in the AI training set context. In the first category, feeding books and articles into large language models, that was the case New York Times versus Microsoft, which concerned unlicensed use of New York Times articles in ChatGPT's data sets. The Times alleged that OpenAI not only used the materials to train its model to answer prompts generally, but also occasionally produced exact or near exact copies of the New York Times copyrighted works. So to the extent ChatGPT would produce an almost exact copy of the Times articles, this would allow them to circumvent the New York Times paywall. They extract a fee for anyone who uses their articles. And they challenged whether this could be fair use. This case is still pending, and it remains to be seen what will happen with that. OpenAI is making similar arguments in other related cases. Authors Guild versus OpenAI was filed in September of 2023. There were copyright infringement claims related to AI training data. OpenAI argues that ChatGPT only produces replicas of articles or other literary works through manipulation and misuse. In the second category, where you feed visual art and photography into generative AI generations, we have the case Anderson et al. Versus Stability AI. There, the plaintiff was a graphic artist and filed a class action on behalf of artists challenging the use of their works as training images in Stable Diffusion, which was a generative AI image generator. Many of the claims were dismissed on fair use grounds. The direct copyright infringement claims, however, remain unresolved. And the judge there held that rather than decide this at the motion to dismiss stage, it would be best to resolve this after there had been discovery and perhaps at the summary judgment stage. Getty Images versus Stability AI. This is a challenge by Getty Images alleging that Stability AI unlawfully trained its generative image model Stable Diffusion using millions of copyrighted images from Getty's catalog. They have millions of images that one may use, and oftentimes artists and other folks will go to the Getty catalog, but there's a fee, a paywall for that. The parties are fighting over whether jurisdiction and venue are proper, and there is a parallel proceeding between the parties in the UK courts. Stability AI has invoked the UK's pastiche exception to copyright, which is their analog to fair use. So the issue could have some disconnect if there are decisions from both UK courts and the American courts on this issue. The third category is the one case where a federal district court has provided guidance on fair use. In Thomson Reuters versus Ross Intelligence, Westlaw's parent company, Westlaw, you know, is the legal research tool, sued Ross AI, which was a startup, in the District of Delaware for copying its headnotes. Westlaw alleged that Ross utilized its headnotes to create questions for a series of legal question and answer memos that constituted Ross's machine learning and training. In its motion for summary judgment, Ross argued that its use of Westlaw's headnotes and key number system was fair use because users who copy material as a minor step in creating a new product are engaging in transformative fair use. The Delaware District Court denied summary judgment on fair use as it was disputed whether or not Ross used Westlaw headnotes simply to learn language patterns and produce unprotected judicial opinion quotes, which would be fair use, or whether Ross used the headnotes to replicate Westlaw's editor's creative expression. Ross argued that its use was not transformative, which is a step in the process toward a new expression, and Westlaw argued that the use was not transformative. Judge Stefanos Bibas found that factor 2 will likely favor fair use because headnotes are not close to the core of copyright, but factual determinations to come on transformativeness could still change the outcome in this case. Factors 3 and 4, including whether it is in the public benefit to allow AI, such as Ross's, to be trained.
Apologies for factor 3 and 4. Due to time constraints, maybe let the audience refer to the booklets if it's okay with you. Apologies due to time constraints. That's what we are going to do. Now, you talked about various U.S. cases, and I really thank you for that. Now, as you can see, in the appendix, we have 5, well, up to Appendix 6, their summary of current trends and cases, which will be very helpful to various practitioners.
한국에서의 상황에 대해서
Next, we'll move on to the Korean context, and that will be presented by Mr. Son. And 10 minutes, please. Thank you. Hello, I am Son Young-on. I've been working in the IP High Court of Korea till February this year, but then now I am working at the Andong branch of Daegu District Court covering criminal cases. I'm very pleased to see you all again. And as you are all aware, the AI is such a big topic in all the field, including the IP area, so I am very honored to be part of this session. And due to time constraint, I will jump right into the presentation. And I would like to say before I do that a lot of the good information was given by the earlier 2 judges, so I will skip the parts that are overlapping and only focus on the parts that are not covered yet. And the first one that I want to talk about is the AI related, IP related issues in Korea. And the Dabus case is such a big case in Korea, so I don't think I will need to go through all the details, but what I want to tell you is that the plaintiff lost both the first instance case and the second instance case, and it is now pending in the Supreme Court. And with the development of artificial intelligence, when it comes to especially the IP area, a lot of different questions and discussions will arise. But now I think we are still at an imagination stage. We cannot really clearly tell what the results will be like. And this was actually touched upon in the earlier session, but as the AI is more widely used, we will need to adjust the level of the skills that are used by the FOSITA, so that will still need to be, defined. And how much of the contribution assessment should be done for the inventor when we are calculating the invention award is something that we will need to also think about. And as the artificial intelligence can analyze a huge amount of data in a fast pace, we will be able to see the previously non-obvious invention becoming obvious in the future, and that will actually have an impact on how we are judging the inventive step. And it's really hard to predict the future, but we will always have to be very interested in this topic to be able to be ready when we need to face the issues that are directly related to AI. And now let me move on to the copyright infringement related to AI. We don't have such a case in Korea yet, but as the Gen AI, including ChatGPT, is widely used in South Korea, and many Korean companies are also using and developing new AI platforms and engines. So I am sure that there is a possibility of having this type of litigation in the future, even in Korea. And when it comes to the copyright infringement suit that could be brought about related to the artificial intelligence, we will have to think about whether the fair use provision can apply. Korean jurisdiction also applies this provision, but the key details are laid out in the booklet. And according to the provision, this is very similar to that of the U.S. It shouldn't be colliding directly with the general use of the work, and if it is not undermining unfairly the fair and reasonable profit of the author, then you can make use of the work. And when you're making a judgment, you will have to consider the purpose and the characteristics of the use and the type and the purpose of the work. And thirdly, you will have to consider the importance and the percentage of the quote having in the whole of the work, and you also have to consider the market value and so forth. And recently, there is one case where the Supreme Court talked about the criteria of the fair use provision. So let me share with you that. The plaintiff here in this case was a copyright trustee, and the defendant was a company that made the academic tests. And the defendant actually uploaded the work that included the copyrighted material of the plaintiff, and the plaintiff filed a suit against the defendant saying that the defendant infringed upon the copyright that it had and sought damages. And there are details, but let me skip the details because that is available in the booklet because of the time constraint. And the criteria that was used is slightly different from the U.S., so please refer to that in the material, please. And to give you the conclusion, I mean, in this case, the Supreme Court held that the disclosure or the publication by the defendant had the public interest aspect to it, but it held that it cannot be considered, the publication cannot be considered transformative. And secondly, the defendant did not receive permission from the plaintiff, and it did not put in place the prevention of reproduction prevention mechanism and just publish the work online. So the Supreme Court held that it is difficult to consider that it is the fair use of the work. So this is going to be a very important case that we will have to consider when we are thinking about the copyright issues related to the artificial intelligence training data. And let me move on to the next topic, which is TDM, text mining. I will not give you, I think, detailed explanation of what text mining is, but in the process of analyzing a huge amount of data, you are collecting and analyzing the data, and the reproduction action that is engaged in the process, is it going to be causing any copyright issue? That is a really important question. And we did have in Korea have discussions about the TDM waiver being newly included in the legislation. We did talk about that as part of the bill as well. And there, the revisions, the proposed revision drafts actually apply a really limited scope for this exception, so that the rights of the copyright holder can be protected, and while the development of the AI can still be pursued. But about the bills that are proposed, there are criticism that the definition, the narrow definition that was given, was still ambiguous. Unfortunately, the bills are not. The bills were scrapped because of the end of the Congress term, but I think this type of discussion will continue to be held in the future. And let me move on to the next topic, which is the royalty with regard to the AI training that I use. So as the AI technology develops and the AI-based content becomes more commonplace, the remuneration to the copyright holders will need to be made in a reasonable way. It seems clear that it is needed, but this is the area that still needs further discussions. Nothing is clearly decided yet. And personally, if a work is used for the training of an AI, it is not exactly like a traditional use. It is not, felt or enjoyed by its emotions, or the thoughts are not directly felt or entertained. So if the same kind of approach is used for the royalty calculation, it may not be reasonable. So it will have to be thought of in a slightly different way. And in terms of how the remuneration would be made, I don't think that there are many discussions held in Korea. I mean, we do have some discussions taking place, but it's not very much. But we will have to think about a balanced way where we can still protect the rights of the copyright holder, but still can incentivize the development in the AI industry. And lastly, I would like to talk about whether the copyright can be acknowledged for the output from the artificial intelligence. Well, as in the US, in Korea, I mean, the copyright or the work, the nature of the work cannot be acknowledged for the output that was created by the AI, and the AI in and of itself cannot be the author either. But if there is the, for example, adjustment or the reduction or the increase or the editing to the AI's output, then and there the creativity of the human being was involved, then on that one the copyright can be acknowledged to a natural human being. And I do have some examples here, but please refer to that from the booklet. So this will be the end of my presentation. Thank you.
네, 대단히 감사합니다.
Thank you. That was a limited time, but thank you for the summary. And I would like to once again give a summary myself, because this can be a rather confusing topic. I mean, AI is collecting training data, and it uses it for training, and they say that they delete it. So you will be using it for the prompting purposes, and the output that you get is actually a creation from the AI. It's not the direct use of the source material. That's what the AI operators say. So we have two questions. I mean, when the material is used for the input, is that the infringement of the copyright? And most of the discussions focused on this first part. There, that's related. We do have the reproduction related question. And the TDM provision was actually legislated in Korea even before in the US it was legislated even before the ChatGPT, and we try to do that too in Korea, but then it is met by a strong resistance. And the next one, the second question, is around the output from the AI. And as everybody explained, I mean, there are a lot of different aspects to it, and there is a question of whether the output is infringing upon a different copyrighted work. So they say, the operators say that the materials that are used for the training is deleted, but then that actually gives rise to a different problem too. And another question at the output level is that the output in and of itself, can it be protected as part of the copyright law? And many view it like a camera, and that is a starting point of the discussion. So if the output is predictable, maybe this is a means. And how detailed should we be when we are writing the prompts? I mean, these are the questions that are raised when we are having the related discussions. And please have a look at the booklet for detailed information that the panelists were not able to deliver to you in person today. And let me move on to the part two. Part two is an even wider topic. So how to use AI in legal proceedings. So the Supreme Court in Korea is very much interested in this topic. And we have given the questions like the following. So you're using the AI, and where can we actually use it? In what field? And many countries will have different ideas, so we're asking what the views are in different countries. And the second question is around the potential challenges. Security, privacy could be potential challenges you may face. So what are the solutions that you have in hand? And in the US, we had the Compens case too, so we would love to learn more about those aspects of challenges. And the third thing that we would love to learn from you is if there are any bill that is pending or any regulation that is being drafted related to this, we would like to learn more about that as well. And there is some discussions around making it obligatory to to write down or disclose the source when the materials are used for the AI. And we also would have to, ask like small questions like what will happen to the legal professions and so forth. So on all these aspects, I would like to ask you to give a comprehensive answer. And the first one to answer would be Feddersen from Germany, and I will give you 5 minutes.
Thank you very much. Now, I'll start with what I know best, that is my own job, being a judge. And the question arises whether we can imagine something like automated decision-making. And the answer to that is quite clear. We might be able to imagine it, but whether it is admissible is a completely different question. Because, and I'm speaking now from a German point of view, having our constitution in mind, judicial power is, as of the constitution, to be exercised by human judges. Therefore, I would clearly state that the substitution of human judges by AI is just illegal. I have put down the relevant provisions in my presentation in the booklet. I'd like to mention that the European Union holds a similar point of view, because in Recital 61 of the AI Act that I have spoken extensively about provides that the use of AI tools can support the decision-making, power of judges or judicial independence, but should not replace it. The final decision-making must remain a human-driven activity. And that leads me to the second aspect. What about assistance in preparation of decisions? And I would say that, and I think that is a view that is quite common among German judges, you could imagine assistance in preparation of decisions by automated systems, as long as the human judge is the one who has to take responsibility for the decision, knows and controls the substantial and procedural basis of the decision. And that, of course, is a problem if, and maybe because, and if, I don't know, maybe that will change at some point. But I think as of today, AI does not guarantee transparency, explainability, and verifiability of results. The black box problem, and I would clearly say that I, as a judge, cannot take responsibility for a black box judgment. There are also strong reservations towards AI among my colleagues as far as criminal proceedings are concerned. We think of the risk of implemented discriminatory tendencies, lack of fairness, insufficient transparency, objectification of defendant, if that is meaningful. Assistance, yes, but as I said, we need transparency, explainability, and verifiability of results. Another aspect I'd like to cover is the question, and unfortunately I will keep my remarks very brief at this point. What about application of AI assistance in German judicial procedures as of today? And I must say, as of today, there is no standardized operation of AI assistance in German judicial procedures, but at least there are several projects that aim at the development, the experimental application of assistance systems. It starts at a rather basic point, I would say, extraction of metadata, running keywording and research databases with the help of AI. And now it gets more interesting because we have quite a lot of mass proceedings. I'm a little shy of mentioning the word diesel scandal here, but I mean, you probably know what this is all about. And the German courts are basically overwhelmed by a tsunami of diesel proceedings, even my court nowadays, because at some point, the courts of lower instance have have done their work, and then it ends up at my court. And we have the challenge, and we have talked about this and heard about this before, huge amounts of pages and thick files and so on, how to deal with that. I really would welcome software that helps to recognize text patterns, at least, because law firms, big law firms, very often use text patterns and put them together in a rather, I would say, unique way, and you'd like to find out whether this case that you have before you really is different from the one that is next in line. So this is something that could really help us, recognition of text patterns and structured presentation of pleadings and arguments. So in my view, this is the most desperately, longed for AI solution that we really need to cope with certain kinds of proceedings. Well, also, maybe not so important, chatbots for information, anonymization of court visits. We have talked about that aspect in some time at this conference. Could also be done by AI, maybe. Thank you very much.
네, 대단히 감사합니다. 시간을 잘 지켜주셔서 대단히.
Thank you so much for keeping the time and for your insight. And I would like to move on to the next speaker, Judge Matsumoto.
Use of AI is not that common in U.S. courts at the time, but our Chief Justice of the United States Supreme Court has recognized that AI has the potential to make courts more accessible to pro se litigants, that is, people who cannot afford a lawyer. The flip side concern, of course, is that we will be flooded with a lot of lawsuits if AI is permitted to be used by pro ses. Like Judge Feddersen, we are very concerned that the judge's function is a human function. We are to exercise our judgment, our humanity, our compassion, and our legal analysis in deciding issues of importance. So I don't know that judges will become reliant on AI. I think part of the problem is when conducting legal research, AI can hallucinate, which is the false information or incorrect citations. It could also rely on biases, both racial, socioeconomic, and otherwise, to result in unfair findings. In one case, a judge in my circuit, Judge Kevin Castell, sanctioned two lawyers $5,000 each because they submitted a legal brief that cited a number of cases, but lo and behold, when Judge Castell and his clerks looked at those cases, they were completely made up. So although lawyers may use AI, it is really a good idea to check and make sure that you're citing real cases. I believe that Michael Cohen, the famous former lawyer to Donald Trump, and who's already been disbarred, mistakenly provided his own lawyer with fake cases created by a program when a motion was submitted to federal court. With massive amounts of data being exchanged in discovery, AI can assist in sorting and searching for relevant information, and AI certainly can help with voluminous trial transcripts and searching keywords and that kind of thing. Judges would be loath, I think, to use AI to calculate sentences, bail risk, and recidivism risk, because there is an argument that AI is not very transparent, and a defendant who's facing the loss of liberty has the right to understand what factors a judge has considered in deciding whether they maintain their liberty. Human oversight is always going to be an important factor. And when deciding risk assessments, again, the courts have to be very careful that whatever algorithms they use are not going to have implicit bias in them. So I think that is probably where I will stop, with plenty of time, hopefully, for you.
예, 대단히 감사합니다. 대단히 감사합니다.
Thank you so much. And you have given us such a in-depth material, so I ask everyone in the audience to read them afterwards. And I believe Judge Kwon have prepared a lot, but could you please give us the presentation in 5 minutes?
Yeah. Hello, everyone. We are almost there. It's truly an honor to take part in this conference and this session, and at the same time, it's a burden to be the very last presenter in front of all the tired faces. I actually prepared a fancy slide which would last for about 20 minutes, but I cannot beg for your more effort and time, so I think I'll just skip some of the parts really quickly. Actually, my slides was to be divided into 2 parts to give some technical insights on AI in legal context. This is drawn from my previous slides. I often give lectures to lawyers, judges, or law students, but I'll just skip the first part. And we will straightly jump up to the second part. I'd like to explore how the Korean judiciary is working to adopt AI technology. Just look around what I've prepared for. Machine learning, how different concepts of AI, machine learning, artificial neural networks, deep learning relate to each other. So there's a concept of rule-based model and learning-based model. It can be compared to a civil law system and common law system actually. Civil law system heavily relies on codified statutes, while common law is developed from case precedents. However, this is not the case for today's world. And machine learning and artificial intelligence these days do not really purely rely on machine learning. It also has code-based, rule-based code within them. Machines perceive the world in the forms of zeros and ones. And you see the Python code, which the artificial intelligence really is, you'll see all the arrays of numbers. And the AI converts words into numbers by technology called word embedding, which is so when you convert words into numbers, you can actually plot the words into imaginary spaces, and the distances will reflect the relationship between different words. And from that, we can actually pick up a context from words. So what it really means is that machines just adjust numbers. They do not really recognize variables as humans do, often with bias like race or gender. And at the same time, they cannot, if data is not given as input, they cannot consider them. And even certain attributes like race or gender to avoid, let's say, to avoid discrimination, they will still find certain indirect relationship and pick up as at least influencing factor. This is sometimes called proxy discrimination. What AI actually do is sometimes divided into 2 categories: classification and regression. Classification is to divide categories, and this is what we do in legal decisions as well. Like in criminal cases, we decide on guilt or innocence, while sentencing being regression, which is to evaluate numbers. And it's the same in IP law. we decide on novelty, inventive step, or non-obviousness, likelihood of confusion, but we also calculate damages. But while AI can do these kind of tasks, fact-finding should precede those tasks. Which means we need to extract relevant information from complex records and decide what to input as data. And while a machine being not able to pick up on human intention, credibility, contents, or at least if it's not input as data, or it's still challenging for machines. So the full automation of decision making is not quite within immediate reach, I would say. And aside from those two tests I mentioned earlier, classification and regression, AI can also generate sentences, which is just to generate probable sentences according to criteria of coherence. A researcher, a professor in University of Washington, Emily Vander, once mentioned that, referred to AI as a stochastic parrot. So we need to take that in our minds. Now let's briefly explore how what Korean judiciary is doing to adopt AI into their system. So you might be already aware of Korea's e-litigation system. It's come quite a long way since 2010 with patent cases, but it's become outdated and complex. And next generation e-litigation project is to streamline and modernize the system with AI with AI tools incorporating AI tools in that, and it's under testing phase with service to launch soon. So one key feature of this project is the intelligent search model, which enhances search relevance by utilizing natural language processing and analyzing user behavior, for example, log data to recommend similar cases. Another important aspect is the issue extraction model, which organizes arguments in tabular form. Judge Sugiura mentioned this kind of thing earlier today, and highlights repetitive content to allow judges to avoid from reading repetitive content and connecting written arguments to related evidence. AI also supports case management, and this project also includes automated error detection and advanced calculation tools. Another significant aspect is improving public access to justice. The litigation assistance will provide 24/7 guidance for litigants and enhance accessibility for people with different abilities and facilitate better communication between courts and litigants. Plus, there's a predictive model that analyzes documents to suggest early settlement options, aiming to resolve disputes sooner. To ensure the reliability of such technologies, the Judicial Policy Advisory Committee, an advisory body that deliberates on judicial policy, which is proposed by the Chief Justice, has recently issued recommendations on AI use in judicial proceedings. And members of the Association of Korean Judges for AI Studies are also drafting guidelines for judges. Let's take a look at some specific legal and ethical challenges that AI introduces in judicial proceedings. First up is bias. This often comes from data than algorithms themselves.
우리 고문사님 죄송한데
Apologies due to time constraint. If you could finish up within 2 or 3 minutes, that would be very much appreciated.
마이크를
Accountability, privacy, and security will be also a big concern. In legal education, so to look ahead, emphasis on AI literacy, ethics will be included in legal education. It will probably influence legal professionals, professions for newly started lawyers to have difficulties in finding opportunities for traditional training course, but at the same time, AI proficiency becoming a cutting edge. Like someone once said that wise men will become wiser and narrow-minded will become even more narrow-minded. And judicial administration will strongly rely on data-driven decision-making. Thanks for your attention.
모두 발제자분들의 너무나 좋은
Yes, I mean, I can tell they have a lot to say and they're so insightful, but I am sorry that I was only able to give you a limited time for all the panelists. So this would conclude this session 5. Well, we were expecting to have the Q&A session at the last, but then we do ran out of time, and this is actually the topic that we cannot really give you the clear answer as of now, so that is why we would like to skip the Q&A for today and hope to have this session as the first session maybe in the next conference. So, and please have the discussions afterwards so that we can share our thoughts about this topic as well. And if you don't have any additional comment, we would like to wrap up the session here. Thank you so much for all the input.
네, 좋은 말씀 감사드립니다.
Thank you so much for all the contributions. Please give them a big round of applause once again.
지금 잠시 무대를 정리하겠습니다.
So we will clear the stage, and I would like to ask the audience to be seated for the closing ceremony.
예, 모두 착석해 주시기 바랍니다.
I would like to ask all the audience members to get seated.
예, 대단히 감사합니다. 안타깝게도
Thank you very much.
이제 컨퍼런스를
Well,
마무리해야 할
we are
시간이
at the end
되었습니다.
of the conference.
마지막으로 특허법원 구자헌
Lastly, I would like to
회사가
ask the
있겠습니다.
Judge
박수로 환영해 주시기
Kujahon of
바랍니다.
the IP High Court of Korea to give us a closing remark. Please give him a big round of applause. Was long today's, and I'd like to thank all the international guests and also the IP judges here and experts here for staying with us until the end. Thank you so much for taking part in the 2024 International IP Court Conference. This year marks the 10th anniversary of the conference, and in this conference we talked about different topics such as preferred forum in international IP disputes, doctrine of equivalence, emerging issues in pharmaceutical and biotech invention, best practices for efficient litigation process, and strategic directions for the development of the Korean IP litigation system and artificial intelligence. We were able to learn so much from the presentations and discussions by the panelists who traveled from far and across the world. And the knowledge and the experience that we were able to gain from this conference would be a great foundation for the further development of the patent law. And this session was sponsored by Chief Judge Jin Sung-chul of the IP High Court of Korea, and also it was serving as a really important platform for all the IP experts around the world. So I would like to ask the IP High Court of Korea judges to stand up so that we can give them a big round of applause for their hard work organizing this event. And there were a lot of support given behind the scenes. Director Min Dong-won of the IP High Court and all the staff members of the IP High Court, thank you so much for all your hard work putting together this wonderful forum. And the IP High Court Judge Han Ji-yoon, who was the core spirit of the organization. Thank you so much for the hard work that you gave into this conference. And we hope to be able to have an even better program for the next year when we have the 11th conference. And this concludes the 10th International IP Court Conference. Thank you, everyone, for your participation. Please give them a big round of applause. Thank you. So the two-day conference, 2024 International IP Court Conference, is now coming to an end. Hope you had a very valuable time, insightful sessions, and I hope to be able to have a fruitful discussion going forward. And this concludes the IP Court Conference of 2024. Thank you.
이번 행사를 빛내주신 참여 패널 및
The
준비위원들은
panelists and the organizing committee members, we will take a group photo to celebrate the event, so please come to the stage, and after that